Where is everybody?
Mark is at camp and Tom is allegedly on his way. Yeah. But we've got quorum, so we can get started at 8:30 if he's not here. How's Canada? Ed, can you hear us?
Yes, I can hear you. You're a little muffled because it's coming over the microphone. I mean, it's loud enough, but
Okay.
it's a little hard to understand. You said Mark is where? Is he on
Mark
his
is,
way?
no, Mark is at camp and he doesn't have internet there, so he is absent.
Oh, I see.
Yeah.
So he won't be there. And here's Tom, so we're all set.
Now, just a heads up before we vote on the agenda, I have two requests from people that may impact it. So I'll do those before we vote.
Okay. And
For you,
and let me just say, Kit, I'm sitting up here in the fog, and occasionally that degrades my internet. If I disappear, I'll just try to get back in.
okay.
So should we call the meeting to order first before you make those amendments or requests about the agenda?
Yes, please.
Okay. So I think not hearing any objection, I will do that. Good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room and online. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes total may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted during the investigation, relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised the commissioners may ask questions, and I'll ask each of you to introduce yourself as you come to the podium. Thank you. Kit,
Yes.
before we take a motion on the agenda?
Yeah. So I have two requests regarding today's agenda. The first is a request in E 23-0253 Walsh versus Guidehouse. This is on the consent agenda and the complainant has requested to withdraw his case. Usually when we get a request like that after the report has issued, I recommend that you do not allow the withdrawal, as we have already invested significant commission resources in that case in completing the investigation. I think we probably ought to take both of these separately, so I would ask for a motion on whether or not to allow that request.
Is
To deny the
is the
request.
Walsh case
It's on the consent agenda, Ed.
yes, no, I see it. I'll second the Megan's motion. Question under discussion under the motion. Is
Sure.
the recommendation for a reasonable grounds finding?
Uh, it is not. It's a no reasonable grounds case.
Okay. I just was expecting that it would be, and that's why we would deny it because we have an interest in pursuing a remedy, but
Any further discussion? Seeing none, the commission's remote participation policy requires the commissioners to indicate their vote both visually and audibly. So if you are in favor of the motion, you will vote yes. Commissioner David?
yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
And the second request is from Catherine McSweeney, Katie McSweeney, in the second case on the hearing agenda, McSweeney versus Drummond Woodson, E23-0340. She emailed last night to say that she has come down with the norovirus from her toddler and is unavailable today, and wonders if we can table that case to either August or September. I have not heard from Respondents Council. I actually got an away message from her, since he's on vacation. So I don't know, is there somebody online or here for Drummond Woodson?
Laura right out.
Laura is usually Maine Health. Oh, yeah. Is there somebody here for Drummond Woodson? Okay, so I have this one is all you guys. I got no stake in this.
I'll move that we grant the motion to continue.
Do I have a second?
Continue till next time or continue today?
No, continue the case.
Well,
Okay, got it.
continue today. No,
Oh.
not continue to do it, to grant the continuance to push it off. I wasn't specifying whether it should be August or September. I would let Kit decide that on the workload.
Did the complainant copy?
She did.
Respondents Council?
She did,
Okay.
and I emailed them separately this morning.
Okay.
But it did come in last night at like 7:30.
We haven't heard from.
But Respondents Council, as far as I'm aware, is Melissa Huey. I emailed her and the other two comments copied on that email, and I got a vacation message from Melissa. So I don't know who was planning to be here for that hearing today, but they may show up when the hearing agenda actually starts at 8:45, and we can ask them then
I wonder if we.
about August.
I wonder if we do that.
And I'm assuming that someone from Drummond Woodson would be available on either of those dates. So we could move to continue and figure out which of based on how many cases we're gonna have at each of those meetings and people's availability, which one.
I mean, I would like to hear from Drummond Woodson's counsel, so I wonder if we wait until 8:45 and address the matter then.
Okay.
It's the second case of the agenda.
It is the second case on the
And
agenda.
we can't approve the agenda until we know what the agenda is.
I think we could probably move to adopt the agenda as it is, with the caveat that we will discuss tabling and vote on tabling that case at 8:45.
Yes.
Sure,
Okay.
let's do that. I'll withdraw my motion, and
Okay.
I'll make a motion to adopt the agenda as is, and then we'll deal with it when we get there.
Okay. Do I have a second?
Second.
Okay, if you are in favor, you will vote yes. Commissioner David?
Yes,
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So, then I
Kit.
need, yep,
yeah, no, business meeting.
yes, I need a motion to adopt the June 2025 minutes.
Second.
Commissioner David? Oh, sorry, any
Yes.
discussion? Okay, Commissioner David?
Yes,
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
We have no change in personnel. You have a memo from Jane, which. 5 cases in active conciliation, 2 cases that have failed conciliation, no successful conciliations, and no agreements for you to vote on. So a quick one this time. For case summary, we got 38 complaints in June with a total of 56 respondents. 32 administrative dismissals, including 10 right to sues and 32 administrative dismissals for things like lack of jurisdiction, failure to cooperate, etc. 10 right to sue letters, 4 withdrawals with no benefits. And for predetermination settlements, we had 13, 9 through the commission's mediation program, 4 in private, with a total of about 228,000 to complainants. Litigation, I would ask that we take an executive session. And for new business, you will see that the meetings for this month, August and September, will probably be, as usual, a little longer than usual. We are approaching the end of the EEOC fiscal year, so we're trying to wrap up those cases so we can meet our contract number. The HUD fiscal year ended at the end of June, so we are wrapping up our end of year obligations for them. I have no indication that we will not be paid, so that's exciting. And we're in a little bit of a lull before the supplemental budget process starts, which I expect will be mid to late August. The state budget is technically a biennial budget, but there's always a supplemental budget to do in the off year. So it's not really a biennial budget because lots of stuff happens in the supplemental. And we'll see how that is all going to play out with the federal budget and the impacts of that on the state budget generally. I don't know what that's going to look like, but I will keep you all posted. That has any impact on it. Questions about any of that? A quick one this month, which is nice. There are snacks for those of you in the room. We will order lunch. It is probably going to be a long meeting. Even if the second case is tabled, we've got 7 other cases up here. So have some coffee, have some snacks. Shall we be in recess for 5 minutes, Ed?
Sure.
All right.
So be it.
Saw the financials when I,
Oh, sorry. Yes, I didn't print them out. Because it's not a quarterly meeting. Usually we go over the
Okay.
financial stuff. Then Michael
Okay.
just likes to give it to you.
okay.
Um,
All set, folks? We ready, Kate?
We're ready. Shall we see first if there's anybody here for Drummond Woodsum in McSweeney versus Drummond Woodsum?
Yes, Peter Felmley here for the respondent.
Okay, great. Hi, Peter. I don't think that you were CC'd on this because we don't have you in the system. We have Melissa in there for this case. Ms. McSweeney emailed last night to let us know that she has contracted norovirus from her toddler and is not available today. So we are wondering if the respondent would be available at either the August 25th or September 22nd meeting to continue the case.
Yes, thank you. Melissa did forward me the communications, so I was aware this was going to pop up. I can't speak for Melissa, but I know I'm available on the 25th.
Okay, great. Shall we
I did send a notice of appearance Thursday or Friday.
I think it probably just hasn't got into the system yet.
Okay, no worries.
Yeah, thanks, Peter. I will make sure that that gets in. So then, shall we have a motion on tabling McSweeney to August 25th?
So moved.
Second.
Okay, moved and seconded. Any discussion? Seeing none. If you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. All right, so we will table that case until August 25th, and we'll send out another notice just so everybody has that. And should we send that to you, Peter, as well as Melissa?
Yes, please. Thank you so much.
All right, will do. Thank you for being here.
You're very welcome. Take care.
Okay.
So the first case for hearing is Karen Welch versus Franklin Memorial Hospital, E230231. The investigator's recommendation is for a finding of no reasonable grounds. Therefore, we will hear from the petitioner, and I believe she's online. Yes.
And before we get started, I just want to remind everybody that the commission's confidentiality provisions require that we not use the names of anyone who is not a party to the case. So in your report, third parties and entities will have been given a pseudonym. Please use that, supervisor, manager, etc. Okay, and with that, Ms. Welsh, you have 10 minutes. Do you want to save any of your time to respond to the respondent's presentation?
If I have any time left, yes. I'm not sure that I will have any time, but yes, please.
Okay, whenever you're ready, go ahead.
Good morning. I'm Karen Welsh, the complainant. I'm here to explain why there are reasonable grounds to believe I was discriminated against by my former employer. The investigator erred in her findings and relied heavily on the hospital's legal defense. This left me the burden to show proof of the calculating and manipulative actions of my manager in her transparent efforts to terminate my employment once my attendance became unreliable. Just a few months prior to when the discrimination started, I received praise and recognition from her for my flexibility and selflessness. If I was to refute all of the false and misleading claims made by the hospital's defense, it would eat up all of my time. So I'm here to point out some of the factual errors and omissions in the report and briefly describe what I experienced as the subject of discrimination. All of the following statements are documented in my communication with the commission and investigator. A major omission was the level of severity of my son's condition and the significant interference it caused to both my ability to work and the intense physical and mental toll which affected my ability to concentrate and perform at work. I had little to no safe options for childcare. My son would frequently elope from caregivers, engaged in self-harming behaviors, and repeatedly said that he wanted to die. The investigator described this as difficulties with his disability. Another omission in the description of the very first instance of discrimination on July 25th, 2022 I explained to my manager that I needed to be out for an undetermined amount of time to attend to the severe family crisis, and explained my son's need in detail when she questioned the necessity. Not only did she discourage me from using my approved leave, she told me that I was expected to return to work by the end of the week. At that time, I felt I had no choice but to deny my family's needs and come to work. I had never been treated this way by management before, and it became apparent my job was on the line. The report omitted that my first complaint to Human Resources was made on August 25th, not September 23rd. That day was the day I received my first discipline from my manager, exactly 1 month after the aforementioned conversation. I expressly stated to HR the claims made in the documented conversation, which was written before the conversations, were inaccurate. And I feared I was being retaliated against for attempting to take extended leave for the FMLA which I began to use frequently, compared to my prior perfect attendance, which included picking up an extra shift for several months when the department was down an employee. The report does not accurately reflect my account of the discussion that occurred on September 22nd, which prompted my second complaint to HR the following day. I described it in my rebuttal letter to the commission on November 13th, 2023. Not only did my manager berate me in an intimidating and condescending manner for an extended amount of time in an unscheduled meeting, she told me she had been digging around in a closed employee file from my previous employment at FMH, which was between 2003 and 2007. She did this to show that my performance issues were longstanding. Maine Health legal team even submitted a performance improvement plan from 2005 in their submission of evidence. I think it should be noted that I continued to work for Franklin Memorial for another 2 years after that PIP was written before I left for a different opportunity. So I had clearly brought my performance up to par at that time, making the submission completely irrelevant. The report erroneously states that I received the first of 3 performance reviews outlining my failure to meet performance expectations in October. That was a misquote on her part. To be clear, I received 1 performance review in question during the period of discrimination, which I described. In my letter to the commission, I stated it was my first unfavorable review out of 3 reviews, not the first of 3 bad reviews. The first 2 reviews were great. The report goes on to present Maine Health's legal argument about my performance issues as fact in a timeline that was created by my supervisors after my termination. It took Franklin Memorial 2 months to prepare and produce my employee file after my termination in order to prepare their case. That part of the report is going to take too long to cover, but I wanted to highlight the timeline of events. The defense tries to paint a picture of what was just shy of a 3-month period of corrective actions and tries to indicate I was given ample opportunity to improve my performance when in fact, between August 25th and November 27th, when I was terminated, I worked a total of 38 days. This was because of the days I took off for my son and because I contracted COVID in October and used sick leave. And during that time, I did try to bring my performance to acceptable standards in my manager's eyes and prove that I was worth keeping as an employee, despite the fact that I was never given a performance improvement plan or final warning by management. In fact, I completed several computer-based learning courses on inpatient therapy practices and hospital safety. I requested guidance from Human Resources. I used the Employee Assistance Program, and I attempted to improve communication in the department and clearer understanding of expectations by requesting staff meetings, which had not been occurring. I've attempted to describe in my communication to the commission the intense anxiety that was caused by my manager at that time, which further affected my ability to perform my job. From the first day I returned to work after the conversation on July 25th until I was let go, my manager made it her mission to end my employment. From that day forward, every one of those 38 days I worked, she sat in my small work area at the hospital instead of working in her office, which is in a separate building. She began an extensive audit of all of my documentation from the start of my employment to find any possible errors. She consistently spoke to me in a condescending and demeaning tone. She interrupted my work frequently with unscheduled discussions and questions and constantly monitored me while working and on my lunch breaks. I eventually needed to start eating lunch in my car. I was under constant scrutiny. She interviewed both staff in and outside of my department to gather any negative opinions about me to support her mission. She asked coworkers to write up reports about any negative interaction they'd experienced with me long after the interactions occurred. I'd like the commission to consider the very limited opportunities I was given to improve, the lack of response regarding my complaints of retaliation to human resources, and the suspicious nature of abruptly terminating me after only a documented verbal warning and a documented written warning. Leaving aside how unfounded and unreasonable the disciplinary action was. The defense makes its claim it's within reason to terminate me based on the safety risks of my performance. If that were the case, there is no way to explain that they allowed me to work a full shift on November 17th after making the decision to terminate me on November 16th for safety reasons. Why would they allow such an unsafe employee to work a full 8-hour shift at the risk of causing harm to patients? Lastly, I tried but never received any explanation from the hospital as to why they wouldn't consider how greatly my family situation impacted my ability to work and why they wouldn't consider alternative action determination. I'll be happy to answer your questions at this time. Thank you.
Questions for Ms. Welsh? Okay. Seeing none, Ms. Welsh, you'll have a little bit more than 1.5 minutes when we come back to you. Attorney Rideout, you have 10 minutes. Do you want to reserve any of your time?
I may have 1.5 minutes left that I'll reserve if it works out that way.
Okay.
Okay. Thank you. Laura Rideout on behalf of the respondent, Franklin Hospital. I thank you for the opportunity to share Franklin Hospital's perspective on this matter and the investigators' findings. The key point I want to make is that the investigators' no reasonable grounds finding is well supported. The evidence reveals that Franklin Hospital discharged any obligations it had under the Maine Human Rights Act to offer accommodations to complainant on account of her caregiver status. And the evidence shows that over a 9-month period, complainant had a pattern of performance issues that were addressed repeatedly via counseling as well as formal corrective action. So we accept the investigator's recommendation and conclude that there are no reasonable grounds to support the complainant's discrimination claim. By way of background, as you may know, Franklin Hospital is part of the Maine health system and is located in Farmington, Maine. Complainant began working at the hospital as an occupational therapist in December of 2020, and her role involved working with patients in the hospital, providing treatment and care during their stay, assessing what their needs would be after their discharge from the hospital, and participating in making discharge recommendations. She was separated from employment in November of 2022 following informal performance management in the form of documented coaching and counseling that took place from the March through August 2022 timeframe, as well as formal corrective action that was issued in late August of 2022, as well as in October of 2022. In April of 2022, complainant began needing to take more time outside of work in order to care for her son, which conflicted with her scheduled work hours. Complainant acknowledges that her supervisor directed her to reach out to the hospital's third-party leave administrator to explore the opportunity for job-protected leave. Complainant did this, and the third-party administrator reviewed and approved her leave claim. Complainant used approximately 13 hours of this leave intermittently through April and July of 2022. She also had, I believe, 6 full-day absences in the 2-month period of July through August. And the last time she used any of her FMLA was on September 1st, 2022, when she used only 1.5 hours. She understood that she was entitled to take up to 12 weeks of protected leave. She knew how to report her absences to the third-party administrator, and the third-party administrator reviewed and approved each of these occurrences of protected leave. The corrective action process with complainant began prior to when she requested and applied for her FMLA leave, and it continued appropriately thereafter in response to legitimate performance concerns related to patient care, patient safety, and billing practices. The investigator noted that there were 7 instances of documented verbal counseling that took place between March and August of 2022 before the first formal corrective action was issued in August. In her objection, complainant purports to identify factual errors or omissions that she believes should change the outcome here. There are a few that I would like to specifically respond to. She first faults the investigator for failing to reference her allegation that she informed HR after her August 2025 documented verbal warning that she felt her manager had made inaccurate claims against her. But whether this happened or not is immaterial because the investigator concluded that complainant had owned up to the deficiency that was the subject of that corrective action when she admitted that she forgot to fill in a section of a patient care evaluation and that she had probably forgotten to do so on other evaluations. So the bottom line here is that there's no evidence in the record to suggest that the documented verbal warning was not properly issued. Next, complainant states that the investigator erred by failing to acknowledge that she was told her separation was based on 4 reports submitted outlining patient and staff concerns about safety and billing practices, but there were only actually 3 reports. Whether there were 3 or 4 is also immaterial. The undisputed fact is that multiple reports were submitted describing deficiencies in complainant's performance, and it was appropriate for the hospital to proceed to the separation stage after it had previously used progressive discipline pertaining to these same types of issues. Complainant also alleges in her objection that there is no evidence of documented performance issues prior to July 25th, 2022, but this assertion is inaccurate. The investigator's report describes evidence of documented performance counseling 4 times between March and June of 2022, including a March incident involving interactions with a patient, April and May incidents involving patient safety, and a June incident involving collaboration with a colleague. The next issue raised by complainant is failure to address reasons why she was not issued a performance improvement plan or a final written warning prior to her separation. This too is immaterial to the ultimate finding. The investigator reviewed the record and concluded that respondent was repeatedly coaching and disciplining complainant on the same types of recurring performance deficiencies, specifically her negative interactions with patients, her inability to work collaboratively with staff, and her improper billing and clinical practices. Her performance failed to improve, notwithstanding this, and complainant was unable to show that these disciplinary actions were false or pretextual. The record evidence also included a copy of the hospital's corrective action policy, which states that while corrective action generally follows a progressive series of steps prior to separation, the process does contemplate the ability to skip a step or proceed immediately to termination if the facts warrant it. In this case, of course, there was progressive performance management and discipline across a 9-month span, which tracked with this policy. And so it really cannot be said in these circumstances that failure to utilize a performance improvement plan or to issue a final written warning evidences any discriminatory animus. Complainant's next point related to report submission of how many occupational therapists left the department since her termination on account of her manager's behavior. I would just note here that there were no allegations about this in the charge or that were made during the investigation process. And there's no evidence in the record suggesting that this was the case. And finally, complainant asserts that the report did not address her position that her manager was targeting her employment after she began taking leave. Hospital disputes this allegation too. Again, the investigator concluded that over a 9-month time period, there was performance management and corrective action that took place. There was no evidence to suggest it was improperly issued. And complainant's assertion that her discharge was the result of her manager's discriminatory animus is undermined by the fact that the corrective action leading to separation itself was based on complaints that were made by her peers, made by her patients, as well as observations by another department leader. And there's no allegations that any of those individuals had a discriminatory animus against complainant. Finally, complainant's successor in the position is also an individual with a similar familial status. So I'll conclude by reiterating Franklin Hospital's position that the evidence in this case amply supports the investigator's recommendation. Franklin Hospital is hopeful that the commission will enter a no reasonable grounds finding. I also want to emphasize the events that ultimately led to separation here. Franklin Hospital's operations are guided by a set of core values, two of which are patient-centeredness and respect. Welsh was separated after several complaints were submitted about patient safety and patient care, including from the patients themselves. That complainant had been verbally abusive, physically rough, and had persisted in incorrect billing practices. So after a 9-month history of attempting to work through similar issues, it was appropriate and reasonable for separation to be the next step. Thank you for your time, and I'm happy to answer any questions.
Commissioner Sanders.
Good morning, Attorney Rideout. I'm curious about one of the paragraphs that reflects the rationale for termination for the complainant. It appears in paragraph I at the bottom of page 4, and then the paragraph moves on to page 5. The last sentence of page 5, second to last sentence of page 5 reflects, quote, during another patient visit, complainant forcefully shoved a bedpan under the patient and possibly damaged his skin. I'm curious, I know that was the report that came in. Did the hospital substantiate that report?
Anytime these types of safety, we have an incident reporting software system. Anytime a complaint is submitted through that system, it triggers an investigation process. And so the individual who is ultimately tasked with reviewing and responding to those incident reports will investigate by speaking with any witnesses, including the person who submitted the report, and gathering whatever other contemporaneous documentation exists describing that incident. I think here, what's also interesting and relevant is the fact that there was that incident, but there were also similar incidents along in that same time frame, and the incidents were similar to other reports that had previously been made about the complainant's dealings with patients. So I think all of that together factored into the decision of the person tasked with responding to this complaint about whether it was substantiated or not.
I think, Attorney Rideout, I think what I heard you say, though, is that at the point of separation from employment, the hospital had the report, but it sounds like the hospital did not have an opportunity to investigate and make a determination of the veracity of the report prior to the time it terminated Ms. Welsh. Is that correct?
I don't know. I don't think so. My understanding is that they did have this report. They had investigated it. They conferred with HR and they made the decision to separate.
Okay, I don't want to belabor the point, but very specifically, had the hospital drawn a conclusion about the veracity of the report at the time that it made the decision to terminate Ms. Welsh's employment?
If it's in the record.
I believe the record reflects the process that was followed leading up to separation, which was investigating this complaint and then reaching the decision that the complainant should be separated on account.
Okay.
So I think the answer to your question is yes, Commissioner Sanders, that there was a decision made about the credibility and veracity of the information in that complaint that was made based on review of the complaint itself, the other contemporaneous complaints, and the history of dealings with this particular individual.
Okay. Thank you for that. And then separately too, understanding that the hospital had substantiated that particular concern, I wonder, had that been the only concern that was substantiated, would that concern alone have in the hospitals, from the hospital's perspective, would that concern alone have served as the rationale for termination, given the harm, right, that Ms. Welsh caused to the patient?
It could have. Obviously, those aren't the facts we have here, where there were multiple complaints and then there was sort of this lengthy time period of very well documented contemporaneous similar instances. So that was the body of information that existed that informed the separation decision. If there had only been one incident, as I explained under the hospital's progressive discipline policy, it certainly could be the case that an incident involving aggressive behavior to a patient, shoving a bedpan under a patient, not only is it undignified, it's rough, it's potentially abusive. That certainly could be enough to move to separation. But here, that wasn't the only fact. And I think the decision was made that, performance improvement plans, we use those when we think someone hasn't been given an opportunity to turn it around and we think they could. Or, final written warning, this person really hasn't been put on notice of the issue yet. We want to give them an opportunity to turn it around. Here, that opportunity had been extended several times, and this incident occurred, and it was a significant and egregious incident. And so, yes, separation was the next step.
Other commissioner questions for Attorney Rideout? Seeing none.
Yes.
Attorney Rideout. Yeah.
Yes,
Commissioner-
no. Yes. Good morning, Attorney Rideout. You said, and I didn't quite get it, that somebody else was in the same familial status. And so who was that, and what's the thrust of that, relevance of that fact?
Yes, Commissioner David, I pointed out that the person who filled the role that was vacated by complainant is a mother with 2 young children, so similar familial status.
Okay. Thank you.
Any other commissioner questions for Attorney Rideout? Seeing none, you'll have about a minute and a half when we come back to you.
Thank you.
Ms. Welch, you have a minute and 38 seconds if there's anything else you'd like to add.
Sorry, it's my turn.
Yep.
Okay, I was looking for the report of the bedpan. It is in the evidence. My supervisor asked this employee to document what she had told her. The incident had taken place like about a month prior to writing the report. It says another incident occurred with a different patient when a CNAs were assisting a patient getting washed up and they needed to use the bathroom. The patient started to use their brief when Karen grabbed a bedpan, shoved it under the patient's bottom without even rolling them, and even got the pad bunched under the patient with the bedpan. That's what the report says. And then from there, it was certainly exaggerated that I could have caused skin damage to this patient. And as the legal counsel states, this was abusive. This is just one example of taking a situation of something where something could have happened but didn't. And all of the supposed statements from other employees in the record are clearly prompted by requests from my manager to put their accounts in writing.
Okay, Ms. Welch, that is your time.
Thank you.
Commissioner, questions for Ms. Welch? Seeing none, we'll go back to Attorney Rideout. You have a minute and 26 seconds.
Thank you. I'll just briefly respond to that last point. There's no evidence in the record that the manager solicited complaints from staff. The record has ample contemporaneous documentation of peers and patients coming forward on their own volition to report concerns. Certainly during an investigation process, if a witness reports information verbally, it's reasonable to request them to submit their statement in writing. So that's part of the investigation file. And I think that's what happened in this case. Thank you.
Commissioner, questions for Attorney Rideout? Being none, we've heard from the parties, and next we'll hear from Nuper Leba, the investigator assigned to this case.
Good morning, commissioners. Excuse me. Both of the parties have represented their cases to y'all as they did to me. And nothing that I've heard today is really changing my recommendation on this, but I am happy to answer any questions that you may have as far as my report goes.
Commissioner questions for the investigator? Okay, seeing none, thank you, Nooper. We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding.
I move to adopt the investigator's recommendation as written, that there are no reasonable grounds to believe that Franklin Memorial Hospital discriminated against Karen Welsh on the basis of her familial status, and the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Moved and seconded. Any discussion?
Yeah, I just want to say to Ms. Welsh, I think you've represented yourself admirably in this proceeding. And I think you've raised a lot of really good points. You've done a lot of things that an attorney would do, poking holes in the accuracy of what's been presented and so on and so forth. So I want to commend you for that. I think that the reason why your case is going to be unsuccessful today, there's just too many performance issues in the record, as the investigator pointed out. And you know, the standard here in front of the commission is an even chance. I just feel like there's just too much, as well as you've done, bless you, as well as you've done in sort of poking holes in the case, you know, in the defense. I think there's just too many performance issues documented here. And I think that's why it sort of goes over the line, you know, the even chance standard goes in line towards the respondent.
Commissioner David?
Yeah, I agree with Commissioner Douglas, Ms. Welch, and you did an excellent presentation. What's missing from me is the tie that's necessary to your familiar status. I understand the controversy and the perception that they're out to get you, and the intricacies of the various incidents, but there's just not the missing. What's missing is the animus that it's unlawful discrimination based on your family situation. So I'll be voting in favor of the motion.
Further discussion? All right, seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Could I just say, I hope your son is doing well. I thought.
So the findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and council confirming the next steps.
Next case for hearing, the second case was continued, right? We've disposed of that. The next case is E230363, Melanson versus Woodland Pulp. The recommendation by the investigator is for a finding of no reasonable grounds on both counts, and therefore we would hear from the complainant.
Mr. Melanson, you have 10 minutes. Do you want to save any of that time?
Yes, if I could.
How much would you like to save?
Oh, a couple of minutes.
Okay, whenever you're ready, go ahead.
Yes, good morning, commissioners. My name's Andre Melanson, and I did not take this lightly to come to you, the commission. I did not agree with the investigator's report, especially on the issue of retaliation for filing a complaint. I've been an employee at Woodland Pulp facility for over 36 years now. And I've never had a complaint in any of my work or anything that I was terminated for. My primary issue with the investigator's report was the Oh, excuse me. The what I feel is the lack of giving weight to two arbitrations that we had over this issue. One was an air violation, and the other one was my termination, where basically all the lying part of the evidence was in there and heard by a neutral third party prior to the commission. I was singled out since November 15th, when the original incident took place with a supervisor. The first initial issue was November 18th by that supervisor. I notified the company on 5th of December at a meeting with my union rep, which the notes were provided. And then the company itself, at another meeting on the 22nd of December, 22, started its harassment by bringing false, unsubstantiated allegations. And it just went from bad to worse. To move forward, when I did have an air violation and I was disciplined for that, the arbitrator found that it was an excessive discipline, and there had not been anyone disciplined for air violations in over 20 years. That was in that arbitration. Moving forward again to my termination or letter of suspension, there were instances in there that, one, I got blamed for something I wasn't even in the mill for, and there was 3 more where I wasn't the operator. I was just extra help in that day. Those were removed from my letter of termination because they would have to discipline someone else. And those letters were provided to the investigator. To not say that I was not singled out is, well, a reach. The arbitrator also, in my termination arbitration, said I was scrutinized more closely and harshly. That was apparent to the arbitrator. And I was terminated without just cause. To go into every detail of this would probably take half a day. The other point that they terminated me for was an occasional, inadvertently not wearing my eyeglasses. Now, I have a string on my glasses like a lot of people do, so I have them with me all the time. That is how petty these the company representatives, supervisors were getting. I also made a claim of over supervising, which was done with 16 other people in our steam plant. Yet I was the only one who filed a complaint. Out of that entire mill, no one has ever been terminated for what I was terminated for. And that's about it. I'll be happy to answer any questions.
Commissioner O'Brien.
Thank you. Good morning. You are alleging you is subject to a hostile work environment based on sex. And haven't heard you, I'm sorry if I missed it, how you're tying this all together. I understand, you feel it was unlawful, and there was retaliation, but where did the sex discrimination come in?
On November 15th, a supervisor came into the control room that I was working in. It was just him and I. And he, through conversation and all that, he came up and said, I want to have a relationship with you. That's what he said. That's all he said. So on the 5th of December, I filed a complaint with HR as per our company policy. He made a pass at me.
Any further commissioner questions for Mr. Melanson? Yes, Commissioner Douglas.
Yes, Mr. Melanson, good morning, sir.
Good morning.
Yeah, I just want, in light of what you just said, I just want to read something from the investigator's report and get your take on it, because you said all he said was, I want to have a relationship with you, the supervisor. This is what the report says. It says, in his account of the November 15, 2022 conversation, supervisor said, quote, so you are excited for Thanksgiving, unquote. Complainant said, quote, what the F does that have to do with work? Supervisor replied, nothing, just small talk, trying to form a relationship with you, with our team members. At that point, you said, don't bother. So the only question I want to, you disagree with that account of what happened. You think your account is that he just walked up to you and said, I want to have a relationship.
Okay.
You understand that right?
Yes, the conversation went forward, but when he said, I want to have a relationship with you, that was it. There was no team building, no nothing.
All right, thank you.
Any other commissioner questions for Mr. Melanson? Hearing none, Mr. Melanson, you'll have about 3.5 minutes to get back to you. Attorney Wargaff, do you want to save any of your time?
Sure, I'll save 2 minutes.
Okay, great. Whenever you're ready, go ahead.
Great. Thank you very much, and good morning, commissioners. Good morning, Mr. Melanson. Hannah Wergaft. I'm an attorney at Brandon Isaacson, and I represent Woodland Pulp in this matter. Thanks, everyone, for your time this morning. Woodland Pulp will ask the commissioners to accept the investigator's recommendation and find there are no reasonable grounds of discrimination or retaliation in this case. Now, one thing I want to address off the outset, obviously there's been some conversation about the history of arbitrations in this case. There were 2 arbitrations. The first was the first arbitration. Mr. Melanson challenged his discipline for a safety violation, and that discipline was upheld by the arbitrator. The second arbitration, Mr. Melanson challenged whether or not there was just cause for his termination, and although by and large, the issue, the various performance issues that were legitimate and led to his termination were substantiated during the arbitration, the arbitrator found that there was not just cause, that the string of violations did not rise to the level of just cause for termination. So as a result, Mr. Melanson was issued back pay for the time that he was out of work and returned to work. And the arbitration decision is in the record, and it's about 25 pages long. It's quite thorough. And the decision was issued last June. So at this point, Mr. Melanson has been back to work for about a year, and my understanding is there have really been no issues. Of course, like I said, the arbitration issues are distinct from this case, right? The Maine human rights claim, of course, is whether or not Woodland Pulp discriminated against Mr. Melanson on the basis of sex or retaliated against him in violation of the Maine Human Rights Act. Now, on the discrimination issue, the investigator concluded that Mr. Melanson was not subject to unwelcome conduct based on sex. There's been some discussion of the alleged comment that was made. I would just point out that in the record are the supervisor's contemporaneous notes from that conversation, and they're quoted in the investigator's report. The comment, "I want to have a relationship with you," was not sexual in nature, was not objectively offensive, and again was a single stray remark as noted in the investigator's report. It simply does not rise to the level of sexual harassment or sexual discrimination of any kind. I do want to address the timing of Mr. Melanson's report. This conversation between Mr. Melanson and the supervisor occurred allegedly on November 15th of 2022. Mr. Melanson was already receiving coaching from the supervisor at that time. The supervisor was new to the mill. He's a much younger guy. Clearly there have been, Mr. Melanson has worked at the mill for quite some time, as have many other employees. And, the supervisor was trying to turn a new leaf and frankly, make some improvements around the mill, not only with safety issues, but also performance issues that had been going on for quite some time. So he was coaching Mr. Melanson throughout the fall, and that's why he was taking notes. Those are contemporaneous notes that are in the record. And when the coaching was not, Mr. Melanson was not receptive to that coaching, ultimately the supervisor escalated those concerns to Human Resources. He did that in December of 2022. And things continued to be a struggle. And HR ended up meeting with Mr. Melanson on December 22nd, 2022, after there was a conversation of Mr. Melanson's performance issues and some of the concerns that the supervisor had been coaching him on. He asked who reported him, who brought this to HR, and then accused someone of making a pass at him, but would not say who. He didn't name the supervisor. He didn't say it was my supervisor. He just said, someone made a pass at me. And the HR manager asked some follow-up questions and asked if there were any sexual comments or gestures made at him, and he said no. No sexual comments, no gestures were made at me, but someone made a pass at me. Without any more information or the identity of that person, there was really nothing that the company could do at that point. It wasn't until January 5th of 2022 when HR again had a separate disciplinary meeting with Mr. Melanson to discuss again some performance concerns that at the end of the meeting, Mr. Melanson said, "I want to make a formal complaint against my supervisor for making a pass at me." So I just wanted to clarify that timing, and I believe it is accurately reflected in the report. But the formal complaint against his supervisor did not happen until January 5th of 2023. Excuse me. I believe I said 2022 earlier, but that's 2023. So after the new year. I also just want to clarify that Mr. Melanson says that he worked at the mill for quite some time without any disciplinary issues. That is not accurate. In 2017, he was suspended for 3 days without pay for cursing and hanging up the phone on an employee at Woodland Pulp's sister organization, St. Croix Tissue. So there have been other performance issues in the past. And again, he was being coached throughout the fall of 2022 on various issues, including smoking in the building, and other safety related concerns. On the retaliation piece, the investigator concluded that Mr. Melanson was not retaliated against, and Woodland Pulp has shown consistently that there was a non-discriminatory basis for his termination, including these safety violations, insubordination, and performance issues. Again, these are discussed at length in the arbitration decision, which is in the record, and again, while the arbitrator found there was not just cause for termination, many of the incidents were substantiated. And, again, Woodland Pulp would argue that there's just no causal link between the report on January 5th and any disciplinary action. And ultimately, the investigator found that there was no evidence in the record that Mr. Melanson's report played any factor or any role in his termination. For all of these reasons, Woodland Pulp will ask the commissioners to adopt the recommendations of the investigator and dismiss this case for no reasonable grounds. Happy to answer any questions.
Questions? Yes, Commissioner David. You're muted, Ed.
I tried to unmute myself. I'm sorry. Good morning, Attorney Wonga. Do I understand correctly that his complaint is that he was retaliated against for the complaint of the alleged sexual harassment?
Yes, that's my understanding.
Okay, so we would have, your argument would be that we would have to find that was a reasonable or an unlawful event that he was reporting, that he was then being retaliated against for what would been a lawful report, right?
Correct, that there was
Right.
some causal connection between the report and the termination.
Got it. Thank you.
Any other commissioner questions for Attorney Burgaft? Okay, seeing none, you'll have about 2.5 minutes when we come back to you.
Thank you.
Mr. Melanson, you've got 3 minutes and 30 seconds whenever you're ready. If there's anything else you'd like to add.
All right, thank you. First up, on the December 5th meeting that we had, the union and I were under the impression we did make the complaint. So that's why on the 22nd of December meeting, we asked about it and still got no really good answer. So on the January 5th meeting is I made it perfectly clear to our HR manager that a complaint needed to be filed. The respondent's attorney said that the first arbitration was on safety. That is inaccurate. That was on an SO2 air emission violation, where I was disciplined excessively by the supervisor. The respondent's attorney also said I was receiving coaching in the fall. That is an untrue statement. I have never had any coaching to do my job. I've been a control room operator for over 10 years. I've had no complaints with my job, my work performance, or anything. Yes, I did have an error violation, and it was my fault. But no one else in that mill for 20 years has been disciplined for an error violation. Uh, all I can say is I was scrutinized a lot closer than anybody else in that mill, in that department. And the only differentiations is I filed a complaint and the company didn't like it. Thank you.
Any commissioner questions for Mr. Melanson? Seeing none, Attorney
Yes.
Wargaft,
Yeah.
oh, Commissioner David.
Yes. Yeah, Mr. Melanson, the complaint that you filed that you say they didn't like was the complaint that there was sexual harassment in that comment, correct?
Yes.
Got it. Thank you.
Attorney Wargaft, you have 2.5 minutes if there's anything else you'd like to add.
The only other thing I would add, and again, I believe this is reflected in the investigation report, is when Mr. Melanson made his formal complaint on January 5th of 2023, the HR manager spoke with the supervisor about the allegation the next day and received clarification about the nature of the comment. And again, the contemporaneous notes, which are in the record. So that's the only point of clarification that I would make. Otherwise, happy to answer any outstanding questions.
Any other commissioner questions for Attorney Wargaft? Seeing none, we've heard from the parties. Next, we'd hear from the investigator.
Morning, members of the committee.
Okay, hang on a second, Grace. Can you come up to the podium so they can hear you on the microphone?
Oh, what do you need me to do?
Can you come up to the podium so you're speaking into the microphone?
You can bring your chair or remove the table if it's helpful. If you need your file. Good morning, commissioners. I considered carefully the submission of disagreement and concluded that it did not impact the findings. So I think the report is fairly complete and I'm happy to entertain any questions.
Questions for the investigator? Seeing none, thank you, Grace. We've heard from the parties and the investigator. At this time, we will be looking for a motion. There are 2 proposed findings.
I have a motion.
Commissioner David?
I would propose to take them together and propose that we adopt the investigator's finding and find that there are no reasonable grounds to believe that respondent discriminated against the complainant on the basis of sex, and that there are no reasonable grounds to believe that respondent retaliated for engaging in WPA or MHRA protected activity, and the complaint should be dismissed.
Second.
Moved and seconded. Any discussion?
I think it's fairly straightforward that he was overreacting to that comment in that context of a new supervisor trying to establish a relationship. Significant that there's no other, by his own admission, any other sexual innuendo or connotation to that, and that's just not justified, and they investigated it and dismissed it, and that they're not retaliating. The actions taken are based on a long history of alleged violations.
Further discussion? Okay, none. The motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing. Ed, could we take
You want to
5?
keep going? Take 5? Yeah. Okay.
Thanks.
We'll be in recess for 5 minutes.
middle of it.
Should we be back in session, Ed?
She took the TLD.
Why can't we just?
I think TLD. I was gonna move it.
I know a lot about this.
You know everything about TLD. You know everything about TLD.
It's gonna bring us back into.
Yes. Okay, we will call the meeting to order. And the next case for a hearing is H 240292A and B, Previte versus James Earl. Oh, they are both plaintiffs versus Alliance Asset Management et al. It's a recommendation for a finding of no reasonable grounds. Therefore, I think there's just one count. We will hear from complainant.
Morning. I apologize. Is it Previte or Previte?
Previte. Thank
Previte,
you.
okay.
Thank you.
You have 10 minutes. Would you like to reserve any of that time?
Yes, I'll reserve a couple minutes for a response. Thank you.
Whenever you're ready, go ahead.
Good morning. Thank you, commissioners. My name is Martha Previte. I'm a complainant in this case. And for the reasons stated in our submission, which is about 15 pages long, I'll try to summarize that in the short time that I have. But due to we believe that there are relevant facts and evidence admitted by the investigator, whereby the investigator's report contained factual and legal errors, and we request the commission finds that there are reasonable grounds to believe that Alliance Asset Management and the Housing Partnership discriminated against us on the basis of disability and denying our reasonable accommodation request to change the smoking policy here. It's the responsibility of the investigator to thoroughly and confidentially investigate the matter, to submit a complete and accurate investigation report, and all of the relevant information obtained by the investigator should be included. The first thing was that the investigator inexplicably failed to acknowledge or address the critical admission by the respondents that the smoking table was preferential treatment for smokers, and that was a clear act of discrimination against non-smoking tenants. The respondent's admission was a relevant fact that was omitted. Secondly, the investigator left out relevant facts in our case by failing to interview our witnesses. Third, the investigator left out relevant facts to our case by failing to investigate the property and omitting that the respondent stated that there were no smoking signs clearly posted throughout the property when there are not. The investigator has a factual error on footnote 5, page 2 of her report that the complainants have provided that we each have mental health conditions, which we do not have. We've never provided that we had any mental health conditions whatsoever. We have physical health disabilities that are severely impacted by cigarette smoke. And number 5, the investigator wrongly stated that the premises doesn't have an anti-harassment policy. This is absolutely untrue. This is a factual error, substantially omitting evidence of the anti-harassment policy, which the respondent submitted. Furthermore, the investigator left out facts related to our harassment complaint, which was clearly indicated on the first page of our complaint for discrimination that we filed with the Human Rights Commission on August 7th, 2024, under number 7, where it said, I believe I'm being discriminated against in housing based on my disability because the landlord failed to act in enforcing the anti-harassment policy. We submitted thumb drives of evidence that were never mentioned in the investigator's report, nor was there any mention of the protection from harassment harassment order that was granted by the district court against our neighbors for harassing us for filing smoking complaints. The investigator proposed as evidence the supposition that the respondent granted past accommodations that so that they didn't discriminate another time. Let me rephrase that. The investigator falsely proposes as evidence the supposition that since the respondent granted past accommodations, that they didn't discriminate another time on our June 18th request for reasonable accommodation. And clearly that does not satisfy the requirement of the respondent acknowledging or responding to a future reasonable accommodation request. The investigator further omitted facts, including a substantial portion of my reasonable accommodation request of June 18th, and omitting the information that I requested in its entirety. My reasonable accommodation requested specifically that the respondents limit all smoking to the smoking table to one section of the premises and not allow residents to smoke anywhere they deem is 25 feet from the building and in the common areas of the premises. The investigator mistakenly claimed on page 4 of the report that complainants hadn't established that we were denied a reasonable accommodation request. And this is flat out wrong, primarily by defaulting. Respondents effectually denied our reasonable accommodation request. They sent out an email stating, "Thank you for your email. Our offices will be closed. During this time, I have limited access to email." That was the only response I got to my reasonable accommodation request. Furthermore, the investigator alleges on page 4 that tenants continue to violate policies and reside at premises are not supported by the record because the respondents issued multiple lease violations. We submitted recorded testimony at the resolutions conference and video and photo evidence in support of our claims exhibits. I had a 200-page brief of evidence that we submitted, including zip drives of photographs of the tenants who had at least more than 3 complaints of harassment and smoking violations. Our record is supported and that indicated that tenants continued to repeatedly violate the anti-harassment policy. And the record is not, as investigator claimed, devoid of evidence or based on our personal beliefs. This isn't a belief system, it's reality and something that the investigator would have witnessed had she properly investigated the case. The investigator omitted evidence that never applied to complainants regarding, I'm sorry, I just have to gather my investigator mistakenly alleges that complainants' next door neighbors were evicted based on my reports. That's not entirely true. The respondent submitted evidence that exhibited indicating photographs of drug use and drug paraphernalia and clear and convincing evidence of smoking that was taken by, I'm sorry?
Ms. Previtt, that's 8 minutes. If you'd like to keep going, another timer for 2.
I'll leave my 2 minutes to respond, but we disagree with the investigator's report and believe that we have established a clear and convincing case that we have been denied a reasonable accommodation based on our disability.
Commissioner, questions for Ms. Previtt? Yes, Commissioner Douglas.
Yes, Ms. Previtt, good morning.
Good morning.
Yeah, so I just want to sort of just get right to the heart of the matter. I'm reading this report here, and it looks to me like you made a bunch of complaints about the non-smoking policy and so on and so forth. But it also looks like the respondents responded to those requests, and there's ample documentation of the fact that, I mean, they did quite a bit. There's one passage here. Second. Between March 1, 2024 and December 2, 2024, these folks issued 5 lease violations, 2 of which were final warnings, evicted complainant's next door neighbor based on your reports, etc. And so my question for you is, just simply put, and I understand you point out a lot of issues with the record and so on. I just want you to tell me, what more is it that you think respondents should have done here?
Specifically, I would have requested that they limit the smoking area. Where I live, it's in a, I have the people smoking in the backyard of my unit, and the smoke directly comes right into my unit. Even this is a non-smoking property. There's no well-defined area for a smoking area that exists. People can smoke anywhere they want to, and that limits my ability to breathe and live healthy in this space. I'm severely immune compromised. I have numerous health disabilities, and I cannot be breathing cigarette smoke in my apartment. What I wanted to request is,
yeah, let me just jump in there.
okay.
The policy was no smoking within 25 feet of any of the common areas such as stairwells, patios, playgrounds, laundry rooms, office, and community room of the rental community. Are you saying that wasn't enforced? Or it sounds like you're asking for them to modify their policy.
Yes, I wanted them to modify their policy because no one adheres to the policy, and it's so difficult to prove. That's the reason why I had so many complaints, because it just happens continuously. People smoke out, like walking outside of their apartment, they'll have a lit cigarette in their mouth. Every time I enter or exit, or I can't even open my windows in my apartment because there's cigarette smoke that's constantly coming in from either people smoking in the parking lot or the backyard, or surrounding my unit. So there's no clean air that I can breathe here in this apartment. They're favoring this preferential treatment for smokers. There are no rights to smoke. There are rights to clean air and breathing clean air in your home. And smokers are not a protected class. I'm a
all right,
Ms. Credit.
Yes.
I've got you. Thank you.
Thank you.
I've got your point. Thank you very much.
Thank you.
Any further commissioner questions for Ms. Credit? Then you will have 2 minutes when we come back to you. Attorney Michalek? I apologize.
Mihalik, actually.
Sorry?
Mihalik, thank you.
Okay.
Commissioners, just as a point of
reserve
order, there are 2 complainants in this matter, and including Mr. Earl, and I don't know what the commission's position is as it relates to Mr. Earl's ability to speak. I just want to be fair.
No, it's 10 minutes per side, basically.
Very well. Very well. I just wanted to make sure we weren't forgetting about Mr. Earl.
No. Do you want to reserve any of your time?
Yes, if I could reserve 2 minutes, I'd appreciate it.
Sure. Whenever you're ready, go ahead.
Very well. Good morning, commissioners. Thank you for the opportunity to address you. Frankly, we're going to be asking that the commission uphold the finding of no reasonable grounds. The gravamen of the complainant's complaint in this matter is that my client did not enforce the no smoking policy. I'll say it again. The complaint is framed as a complaint about a lack of enforcement of the no smoking policy. It's very clear, as one of the commissioners pointed out through his questioning, that my client did enforce the no smoking policy during the period prior to when the complainants made their complaint. Our client sent out 11 different notices of lease violation to tenants when they had evidence that specific tenants had violated that policy. When they had more generalized notice of smoking violations that they couldn't pin on any one particular tenant, they sent out 3 other generalized no smoking reminders to all residents. There's a total of 14 different notices to residents that were efforts to enforce the no smoking policy at the development. But over and above that, one particular tenant, because of Ms. Previtt's complaints, we were able to gather evidence against that particular tenant and bring an eviction case against that tenant. And we initially reached a settlement with that tenant that essentially stated that she had to abide by her lease generally and abide by the no smoking policy in particular. She violated that. And when she violated that, we went back to court. We obtained a writ of possession and we evicted this one tenant by the name of Mia Trumbull.
Please don't use the name of parties, of people or individuals who are not named in the complaint.
My apologies. It is a matter of public record for the commission's record, but I appreciate that. Very well. But in any event, the 14 different notices of violation and the specific eviction case that we brought are clear evidence of my client taking smoking complaints and violations of the smoking policy seriously, enforcing them and taking action. So I think that the investigators' findings, when they found no reasonable grounds that my client didn't enforce the policy, was spot on. They have done so. The second argument that the complainants seem to be making is one that isn't raised in their complaint. And it's important to underscore that. They seem to be kind of shifting their argument here, which is, it seems that now they want to argue that instead of enforcing the policy, well, what if you change the policy? What if you eliminated all smoking at the development? I made this point in our opposition, and that's not what was framed in the complaint. And the investigator appropriately found that the last request of the complainants to alter or amend the policy was made back in August of 2022, well beyond 300 days prior to the initiation of this complaint. So even if the complaint alleged a discrimination on the basis of failure to amend the policy, and it doesn't do that, it was well beyond the 300 days anyway. Further, I think it was a good point by the investigator that she ended up finding that the amending the policy to eliminate all smoking at the development such that no smoke could blow towards the complainant's unit would have been unreasonable on its face. Because frankly, my clients just can't control the wind. Wind is going to happen, whether it's a farm that's far away. There could be, blowing foul odors in an unfortunate direction, or smoking, or whatever. We just can't control the wind. That's a point that I think the investigator appropriately raises. But again, this issue of amending the policy is not even alleged in the complaint. But even if it were, it's well beyond 300 days since the last request to amend the complaint. The complainants raise an issue regarding a June 18th, 2024 communication in which they attempt to claim that the investigator made an error in finding that that was kind of an anchoring event that was a request to amend the smoking policy. That's just not true. That specific communication, which is in the record, again asks my client to enforce the existing policy, not to change the policy, to enforce it, as a point of clarification. The final argument that the complainants make is that somehow my clients are responsible for harassment of the complainants. It appears that there may be some animosity between the complainants and some of the other residents at the development that smoke. The investigator found that there was no evidence that my client has engaged in any sort of protected discrimination or favoritism as it relates to those particular complaints by the complainants. And I think the investigator found appropriately that there was no reasonable grounds for discrimination along those lines. As a final note, in the submission of disagreement submitted by the complainants, they do take a number of make a number of accusations against the investigator in particular, and I'd just like to object to that. I think the investigator did a fine job, was very thorough, followed up numerous times when she was seeking clarification or evidence, and I think the allegations levied personally against her are unwarranted. There certainly was no bias or lack of neutrality as they allege. I'll reserve my remaining, I guess, 3 minutes for response if necessary.
Commissioner questions? Yeah, Commissioner David.
Attorney Mihalik, I understand your point that it's framed as a failure to enforce, but at some point, enforcement of a no smoking policy means that there's no smoking, and at some point, is it not the case that the allegation is that they're not enforcing the policy as evidenced by the fact that there's still smoke? How do you react to that?
We're clearly enforcing the policy of no smoking within 25 feet of the common areas of the building. We clearly are enforcing that as evidenced by the successful eviction, as evidenced by the fact that we sent 14 different notices of lease violation. Residents can smoke on development grounds. There is a particular table that's set up that residents beyond 25 feet that do smoke sit at and smoke well away from the entrances to the developments. They do that. My client has consistently enforced the existing no smoking policy at the development. They just have.
Thank you.
Other commissioner questions for Respondents Council? Being none, Ms. Previtt, you have 2 minutes. If there's anything else you'd like to add.
Yes, the investigator never interviewed any of my witnesses, number one. I wanted to say that. But also the presence of the cigarette smoke, just because they send out complaints to other tenants that they've been violating the smoking policy doesn't mean that they're enforcing the smoking policy. And clearly it shows that, there's a smoking issue here if there are so many complaints about that. Another point is that the respondent admitted that she wanted to make this a place it's better for all residents, not just a select few, which in itself is discrimination, that they're favoring people by putting a smoking table in the middle of the parking lot for 10, 12, 15 people to smoke at, that we have to walk through every time. We can't even open our windows in our house because the smoke from that smoking table comes in. This is not wind blowing across the farm field. This is cigarette smoke, deadly toxic cigarette smoke that's impacting my breathing ability in my own apartment. That's so much so that I can't open the windows in my apartment because there are people smoking out in the backyard all around, and no matter where I open my windows, it's going to be sucked in. There are no smoking signs at all on the premises of this property. And just because that they've enforced that, they've sent out, warning letters to other tenants, or that they've even evicted the drug traffickers that were living next door to me, that were continuously smoking not only cigarette smoke, but marijuana and God knows what else they were smoking, that we had to breathe because we're abutting
Ms. Privet, that is your time.
Okay, thank you. I disagree with the commissioner.
Commissioner questions for the complainant. Commissioner O'Brien.
Thank you. I just want to, bottom line is that you, are you requesting or it's bottom line that you want no smoking in the premises at all, a no smoking policy?
That would be ideal. And if that's not something that can be done, which I believe it can be done based on the Respondents Council's own webpage, that these complexes can be changed to non-smoking, then at least they just limit it to the perimeter surrounding my unit or the parking lot where I have to access. I can't go to my mailbox or go to my car without breathing cigarette smoke from a crowd of people that are outside smoking constantly.
Thank you. And one more question. You've been there since 2015, is that correct?
I've lived here for 10 years, yes.
And has this in your mind experience been an issue from the day you came in?
Yes, it has been.
All right. Thank you.
Thank you.
Any other commissioner questions for Ms. Privet? Okay, seeing none. We'll move back to respondent. You have 3 minutes.
Thank you, commissioners. Once again, I'd just like to emphasize this case is about whether or not my client has enforced the existing policy. They very clearly have. The complainants raise questions about or make the assertion that sending out notices of lease violation or bringing an eviction action against a tenant just aren't enough. As an attorney that specializes in evictions in Massachusetts, Maine, and New Hampshire, I've been doing it for 25 years, objectively and rightfully. In order to bring an eviction case to evict someone, to eliminate a smoker, you have to gather evidence. You have to have evidence to present in court. A judge shouldn't just take my word for it as I stand up in court and say the defendant did this or the defendant did that. That's just not fair. That's not how this country works. You have to gather evidence, and that's part of my job in partnering with my clients is to do just that, to make sure that they button things up, send out notices of lease violation, gather evidence, incident reports, witnesses, and so forth to support things. That's what we did in that one particular eviction case that was brought with the help of Ms. Privet. And my client is committed to enforcing the existing policy in place. Again, this notion of eliminating smoking completely at the development, it's really not before the commission at all. However, there are legitimate questions about whether or not that's a wise policy or not. Some of my clients have seen situations where banning smoking at a development will just push people inside to smoke in their apartments. Which is far worse because it's in proximity and in concentration as it relates to secondhand smoke. So this particular client of mine, the respondents here have decided to, and it's very common, to have a 25-foot no smoking zone as the policy. It's a reasonable policy under the circumstances. They're enforcing that policy as I've indicated, and we'd ask that the commission uphold the finding of the investigator that there are no reasonable grounds here to find that my client hasn't enforced the existing policy. Thank you all.
Commissioner questions for the response? Seeing none, thank you both. You've heard from the parties, and next we will hear from Nuber Leva, the investigator assigned to this case.
Good morning again, commissioners. The parties, again, have laid out their cases very well, exactly like they laid them out to me. Nothing that I'm hearing today or that I read in the submission of disagreement changes my recommendation, and I am happy to answer any questions if you have them.
Commissioner Douglas.
Yes, good morning.
Good morning.
First, I want to say that this is an excellent report, succinct, to the point, informative, so thank you for that. I just wanted to confirm that from your perspective, this case is about enforcement of the existing policy.
Yes.
Thank you.
Mhm.
Any other commissioner questions for the investigator? Seeing none, thank you, Nooper. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding.
Yeah, I move that we adopt the recommended finding and vote that there are no reasonable grounds to believe that the respondents discriminated against Ms. Previtt on the basis of disability and or the receipt of public assistance, and the complaint should be dismissed in accordance with 5 MRS 4612 subsection 2.
Okay.
Moved and seconded. Any discussion?
Just to amend the motion, I just want it clear on the record that in addition to Ms. Previtt, will include Mr. Earl as well in the motion.
I thought he was gonna have a separate chance to present.
No.
No?
No, they're taken together.
Oh,
He's trying.
I mean, does he get a chance to speak?
Generally, when there are two complainants, they share the time.
So each,
Yes.
so they knew that, she took all the time.
That's the way we have generally done these.
All right, okay, well then.
It's the same case.
Yeah, do you want me to make my motion again, or?
Sure.
Just adopt this Sanders amendment, or what's the best course?
Why don't you renew your motion?
I'll
That's
withdraw the prior motion. I'll make a
Okay.
new motion.
I'll be quick.
There are no reasonable grounds to believe that respondents discriminated against Ms. Previtt and or and Mr. Earl on the basis of disability and or the receipt of public assistance. And the complaint should be dismissed in accordance with 5 MRS 4612 subsection 2.
And again.
All right, moved and seconded. Any discussion?
Yeah, I had a comment. I mean, I think that there is a point at which saying that that it's just about enforcement. If the enforcement is totally ineffective and doesn't do the job, then it's not enforcing. But I don't think this case. I mean, I'm a little closer than maybe some of the other commissioners, but I don't think this case reaches that dimension. They clearly they're evicting tenants, they're responding. The policy, for us to micromanage the policy and say, as I believe the complainant actually said at the beginning, that she doesn't like the fact that there is a smoking table at all, is asking us to micromanage the policy, and that's not our function. So I'll be supporting the motion.
This is unorthodox. I do see that Mr. Earl is trying to speak, and so go ahead and unmute yourself.
Thank you. I'd just like to bring up what Martha and I both believe it's one of the most important points, is that Alliance itself admitted there was preferential treatment, and that's never been addressed by Alliance, and that's never been addressed by the investigator. So
You're referring to this, it's in the submission of disagreement, which the commissioners have reviewed that. So, yeah, thank you for making
all
that.
right.
Okay. Thank you, Mr. Earl.
Thank you.
I guess, Kit, that what we're learning is that when we have two named petitioners, we need to make it clear to the petitioners, if they're both showing up, that they need to apportion that 10 minutes amongst them if they don't want one to speak for the both of them.
Yeah, it's
I
in our
think that's
rules.
what. Yeah, it's been our rule, and I think that's
Yeah.
what we're enforcing.
All right. Any further discussion on this one? And am I correct in assuming that you all read the submission of disagreement? You saw that
Yes.
note about preferential treatment for the complainants? Yes. All right, so the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing.
Thank you, commissioners. Have a great day.
The next case for hearing is H250044 ABC and D, Parsons versus Greco et al. The recommendation is for a finding of no reasonable grounds, and therefore we will hear from complainant.
Right, Mr. Parsons, you have 10 minutes. Do you want to reserve any of your time?
No, that's okay. Thank you.
Whenever you're ready, go ahead.
Good morning, commissioners. Thank you for the opportunity to speak. On January 26th, the HOA's annual meeting, just moments before board election, Peter Greeno, acting in his official capacity as a representative of Hellas Condominium, stated the following, quote, "With all the legal stuff, if I don't run and Peter Parsons comes in, who has great experience, who has great skills, he will see into all of our attorney-client conversations and have all of our defense. And there's no way legally to force him to recuse himself or keep that separate. And that means that Mara and I and all the members of the association as a whole immediately lose. We have no defense. That is a direct admission on the record of retaliatory intent. Mr. Greeno did not oppose my candidacy based on conduct. He disqualified me because of proximity to a successful MHRC disability complaint. Any claims raised afterwards about my alleged character or fitness are post hoc rationalizations, concocted later in coordination with legal counsel to limit liability once retaliation concerns came into play. Not one of these claims has ever been supported by evidence, here, in court, or with law enforcement. No action was ever taken by the HOA or authorities to substantiate any wrongdoing on my part. And most importantly, when the board had an open seat and no other candidates, Mr. Greeno still blocked my appointment. If my wife's MHRC complaint played no role, as respondents now claim, why was that the reason Mr. Greeno gave, on the record, the moments before the vote was being cast? Mr. Greeno's intent to keep me off the board had nothing to do with merit and everything to do with retaliation. His own words prove that. I respectfully urge the commission to reject the investigator's report and to find reasonable grounds to believe that unlawful retaliation occurred. Thank you.
Thank you, Mr. Parsons. Any commissioner questions for the complainant? Okay, seeing none, you'll have about 7 minutes and 50 seconds when we come back to you. Attorney Gregory, you have 10 minutes. Do you want to say, you're muted. Do you want to save any of your time?
Yes, I expect there'll be a couple minutes left after I have some brief remarks. Save
All right,
that.
I'll start you at 8 minutes. Whenever you're ready, go ahead.
Okay, thank you very much. Thank you, commissioners. This is a matter I think that Investigator Morse did an extremely good job of investigating the facts, investigating the law, and reaching the decision that there's no grounds or reasonable cause to determine that there's either discrimination because of disability or retaliation due to an association with his wife. And just tacking on to what Mr. Parsons just indicated, suggesting that the evidence supports a conclusion to the contrary, that it was entirely retaliatory. Investigator Morse addressed those issues specifically in her findings and outlined in her report, and I'll point the commissioners to footnote 3 on page 2, in which she identifies specifically that some of the character issues and antagonism coming from Mr. Parsons that inspired Mr. Greeno to reject and oppose Mr. Parsons' candidacy. In addition, just want to point out to the commission that I believe that some of the information in Mr. Parsons' objection was not part of the evidentiary record. In point in particular, there's an undated, unsubstantiated quotation appearing on page 2, page 2 near the bottom, which Mr. Parsons begins, quote, part of it was, and then it continues from there. I've scoured the evidence submitted during the evidentiary portion of the proceeding and found that nowhere. And I think it's also telling that this is unidentified, not dated. It doesn't indicate what form this alleged communication came from, and suggests that the the commissioners would be justified in rejecting that entirely. In addition to those issues, I want to point out that there are at least two notable deficiencies in Mr. Parsons' legal analysis and his objection. First, regarding his summarizing case law and attempt to argue that the quote-unquote associational retaliation is settled doctrine in Maine. First off, Mr. Parsons misstates the law in an attempt to argue that the investigator ignored this quote-unquote settled doctrine of associational retaliation. To support his argument, Mr. Parsons cites to a case Thompson versus North American Stainless without a citation. I think what he was referring to is a case in the U.S. Supreme Court, Thompson versus North American Stainless LP, with the citations 562 U.S. 170. It's a case from 2011. That case, though, was about employment discrimination under Title VII. Neither Mr. Parsons nor his wife brought employment discrimination claims before the MHRC. As such, that case is inapplicable. In addition, Mr. Parsons failed to provide any support for his contention that in Maine there is a settled doctrine of associational retaliation. I believe that statement is aspirational but not supported with the facts. Secondly, Mr. Parsons incorrectly summarizes the Federal Fair Housing Act, which is inapplicable to this matter. Mr. Parsons cites to 42 USC section 3617 in an attempt to argue that the statute, quote unquote, makes it illegal to interfere with any person on account of his having aided or encouraged any other person in exercising a housing right. However, Mr. Parsons incorrectly summarizes the statute. Mr. Parsons argues that the statute refers to housing rights generally, but the statute itself has a narrower scope. The statute relates to persons having, quote unquote, aided or encouraged any other person in the exercise or enjoyment of any right granted or protected by sections 3603, 3604, 3605, or 3606. And if you review those sections, you'll find that those don't relate to any of the allegations Mr. Parsons or his wife made. Those sections refer to issues that aren't in play here, prohibitions against discrimination in the sale or rental of housing, discrimination in the sale or rental of housing, other prohibited practices, discrimination in residential real estate related transactions, and finally, discrimination in the provision of brokerage services. Summing up here, the investigator, I think, did an extremely able job trying to parse through the real emotions that are at play here. I think she found specifically that there's no basis to the suggestion that either Mr. Lawless or Mr. Crawford either retaliated or discriminated. And in terms of Mr. Greeno, I think the investigator did a particularly good job in looking at the relationship between those two men, the antagonism, unfortunately acrimony, the fact that they're engaged in other civil suits, one against the other, and I think reached the appropriate conclusion that that was the animus that led Mr. Greeno to oppose Mr. Parsons' candidacy. It wasn't discriminatory or retaliatory in any regard. Thank you.
All right, so about 4.5 minutes. Commissioner questions for Attorney Gregory. Okay, seeing none, you'll have about 4.5 minutes when we come back to you. Mr. Parsons, you have 7 minutes and 51 seconds if there is anything else you'd like to add.
I don't have anything else to add. Thank you, though.
Commissioner questions for Mr. Parsons? Right. Seeing none, Attorney Gregory, anything else you'd like to add?
No, thank you.
Seeing none, with any other commissioner questions for complainant or respondents counsel? Okay. Seeing none, we will hear from Angela Morse, the investigator assigned to this case.
Hello, my name's Angela Morse. I was the investigator assigned to this case. I don't have anything specifically to add at this point, but I'm certainly willing to answer any questions.
Commissioner Sanders.
Good morning. Just one clarifying question. In your investigator's report on page 4, it's the first full paragraph. Second sentence reads, quote, Reno did express concerns about giving complainant access to confidential board information in light of a pending civil action. Complainant's statement that he intended to file complaints against others who opposed him, end quote. Just to clarify, with respect to the pending civil action, is that a matter outside of and sort of separate and distinct from anything that may be happening in the context of wife's access to the commission process? Is that right?
Yes, it's separate from this case and our investigation.
Thank you.
Any other questions for the investigator? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are two proposed findings.
Yeah, I propose we take them together and we adopt the investigator's findings. There are no reasonable grounds to believe respondents discriminated against Mr. Parsons on the basis of disability, and there are no reasonable grounds to believe that the respondents retaliated against Mr. Parsons in violation of the MHRA, and that the complaint should be dismissed.
Second.
Moved and seconded. Any discussion?
Well, just I don't, to me, this is pretty clear cut. And I may be a bit, pretty clear cut that this is an election and nothing more. I don't see any nexus between what has gone on in the past. It seems somebody wants to be on the board and somebody else doesn't want them on the board, and that's how I see this.
I was going to do exactly the same thing.
Thank you.
And I was just going to also say that this investigator's report is extremely well done and detailed and speaks for itself. So.
Any further discussion? Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you were in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. We appreciate everybody's participation, and we will send a letter to the parties in the council confirming the results of the hearing.
Thank you, commissioners.
Ed, could we take another 5?
Okay. We'll be in recess for 5 minutes. We all set?
Sorry, Ed, I missed that. What'd you say?
It's ready to go.
Okay,
I just said, are we all set?
as soon as Barbara comes back, we'll be ready.
Ah, Barbara's not there. Okay, good.
Right, I'm just. Okay.
Okay, we will be call the meeting back in session, and the next case for hearing is H250053 A, B, and C, Sanborn versus Stanford Management. It is a recommendation on 3 counts for findings of no reasonable grounds. Therefore, we will hear from complainant Ms. Sanborn or counsel.
Do I go? Yep.
Hello. Good morning. Thank you for hearing me. I'm Joanne Sanborn. I come today to try to prove some discrimination for you all. There were some issues at Stanford Management with some security cameras and some issues with a matter of a dog leash. Stanford Management had given me a bunch of violations for not having my dog on a leash. And I didn't have my dog on a leash, and they were giving me violations for that. So I started putting my dog on the leash, but there was another tenant in the building that didn't have her dog on the leash. So of course I contacted you people for that. And then there was an issue with the security cameras. I drew up a little diagram. I don't know if I should show it to you or whatever, as to where the building is located. Let me show you where the security cameras are. But my car was parked in a certain spot, and my tires and my windshields were smashed, and my tires were slashed out of my vehicle. And I asked the property manager, Melissa, to review the cameras to see who had smashed and slashed my tires. And she said that she didn't see anything happen to my vehicle. And I asked her several times, over the course of a couple of weeks, and she said that she didn't see anything. And it cost me a lot of money. I lost my job due to this. I have some pretty bad mental health issues. I hurt myself when I get upset. I did something very wrong. I went out and I damaged another tenant's vehicle. And I picked up charges for doing that, but I proved a point. The very next day, she came to me and the cops came to me, and they had me on camera at the building damaging another person's vehicle. The camera picked me up. I went out the door and I went to another person's vehicle, and it showed me coming out the door and going to a tenant's vehicle over here. This is where my car was parked. And the cameras are right here. And my tires were slashed, but it shows me coming out the door and going to another person's vehicle and going all around the parking lot. But it didn't show, according to Stanford Management, anybody going to my vehicle, according to them. But it clearly, the very next day, showed me damaging another person's vehicle. And I just found that very weird that it would pick me up, yeah, damaging somebody's vehicle, but not somebody damaging mine. The senior property manager, I emailed him and I asked him about this. And his reply to me was that he informed me that the actual footage of the clips in the system had been recorded over in the period in question. But after being asked to look again, she had found it. Now, how can she find something if in the system if it had been recorded over? And I did that to prove a point. I damaged another vehicle's tenant. And I received charges over that. So I'm going through my third eviction right now. I went to court on the 25th, which was Friday. It got extended until August 8th.
Sanborn, I think that can't be in the record.
Oh.
This does happen, so don't discuss.
Oh, I'm sorry. I'm sorry about that. My car was parked exactly where it was on that diagram I just showed you. I feel that I've been discriminated against in many ways. My property was destroyed. My rights to have a safe living space has been seriously violated. I feel unsafe and unprotected in my home. I've recovered a lot of my items have been stolen by Stanford Management. I've recovered some of them back. They've stolen from me. I don't trust the property manager. She allows there's a man in the building that sexually assaulted me, and she allows him to sit in a room that is attached to my apartment and bang on the walls and call me names and harass me all day and night.
I'm not sure.
Excuse me?
I'm not sure that's in the record either.
Oh, I'm sorry. I don't know. Well, it does no good for me to call the cops about this because they do nothing. It makes things worse. The more I call the cops, the more my stuff gets destroyed around the building. I call the cops, my windshield gets broke. It's at the point where I've attempted suicide twice. I find this to be really frustrating and aggravating. It's really overwhelming to live in fear like this. I've been bullied and harassed by Stanford Management for almost 10 years, and I'm really tired of it. My mental health has severely declined. My weight has gone from 150 pounds in February. I'm down to 119 now. I had an amazing job at Hannaford, and I've lost it due to severe stress and emotional breakdowns and very severe costly repairs to my car, which I've had to put really bad tires on to drive up here. You can go out and look at my tires. They're not fit for the road. I don't even know how I made it up here. Melissa gives me permission for my dog to go to the bathroom in a certain spot at the building and turns around and gives me violations for it almost daily. Every time she gives me permission to go in a certain spot, she'll tell me, I don't care if your dog goes to the bathroom there, Jolene. Nobody walks there. And then almost the very next week, I get a violation or written up for the same thing over and over. It's repetitive. It's endless. And nobody else in the building gets violations or cleans up after their animals. I'm at my wit's end. I don't know what else to do. I don't know what else to do. And I ask for your help. I do. That's all I have. I'm sorry.
Commissioner O'Brien and the Commissioner.
I couldn't find when.
I moved into the building and I want to say it was like 2016, 2016 in March.
This has been a continuous.
You know, I've gone through this, yes, yeah.
And in your response that you sent in, your paragraph, you feel obviously that you didn't, since you don't have an attorney representing you, that could sway the case. And I just want to tell you, I'm not sure that an attorney, I think you've done a fine job to get out there. I'm not sure that an attorney would have done anything else. Oh, okay.
Yeah, I appreciate that. Thank you.
Commissioner Sanders, great. Thank you for coming. I appreciate that you came in person. It shows a level of commitment to your claim that I think is commendable, and I echo Commissioner O'Brien's statement on part of this, part of the process.
Scary.
Yeah, I can appreciate that. Part of the process that we employ here is intended to be accessible for folks who don't have counsel for a variety of reasons. So thank you for working through the process with us. I'm curious about, there's a piece in the investigator's report where the investigator lays out the rationale or the reason that the management company issued you a notice of eviction. And there were a variety of reasons why they did that. One of those reasons, of course, they cite to violations of the leash policy, but there were other reasons as well. So specifically, the investigator notes that the reason for the notice to evict is based upon failure to pay an outstanding security deposit, failure to report income for income recertification, failure to remove personal items from the hallway despite repeated warnings. And then it gets to multiple violations of the lease policy, theft of maintenance supplies, and the significant property damage caused by the burst pipe. And so I'm just curious about, you focus on the leash policy and your perception of the lack of fairness with respect to enforcement. Curious about, do you dispute these other reasons?
Yeah.
You do dispute
Yeah,
that.
can I explain?
Sure.
Yeah, as far as the burst pipes go, when the pipes burst that day, the maintenance was in building and he came upstairs to my apartment. The pipes burst not because of the open window, the pipes burst due, the building's over 30 years old. My apartment is the biggest apartment in the building. It was built and set up that way for a live-in maintenance person. They gave the apartment to me because I was due to have dual knee operations, and it was set up, like I said, for a live-in maintenance person, but they gave it to me because I was going to have double knee surgery, and they gave it to me for extra exercise equipment or whatever in my apartment. The maintenance guy came upstairs. It took him over an hour and a half to find the shutoff valve in my apartment. And he had been employed by Stanford Management for 5 months at that time. So an hour and a half after, with all this water damage. And it took him, what was the other part?
Sure. So, the failure to pay outstanding security deposit.
That they never notified me that I had an outstanding balance, and the outstanding balance at that time was only $178. I was making payments of $20 increments each month. I had gotten, it was like $178. And I was making payments of $20 a month. And as far as the check stub payments, I mean, notifying them of the income, I had given Joe Luch my check stubs, but this was after the pipes had burst. And he was afraid that the water damages were going to be pinned on him. he didn't give the check stubs to Melissa Cox. He was going to Bethel that day where she was at the property management up in Bethel. And I believe that he didn't give them to her on purpose because I just find that it was a vindictive thing.
What about personal items in the hall?
In the hallway, those weren't mine. There was a man that had moved in, the guy that had sexually harassed me, sexually assaulted me. He didn't have any furniture. So when he moved in, I had given a bunch of furniture. Well, him and I had gotten into an argument and he had given me back all of the stuff that I had given him, and he had left it in the hallway outside of my door. I had given away all this stuff. I didn't want it back. So it sat in the hallway outside my door. I didn't want it back.
Okay.
I had given it away.
And what about the theft of
The theft, it wasn't a theft. It was a bag. It was a roll of trash bags that I had taken. I was going to help clean up the mess from the water damage.
Okay.
I had taken a roll of trash bags so that I could help clean up the damage that the water spill had cleaned. I wasn't stealing. I was trying to help them. That's all. Yeah. And I'd given it back to them. I was only going to try to help. I had cleaned for them for a number of years. I was a paid cleaner. I had just taken trash bags. I was going to help them clean up.
Any other commissioner questions for Ms. Singh? Seeing none, you can sit down and you'll have 2 minutes when we come back to you.
I don't want to trip. Thank you.
Attorney Courier or Attorney Savage? Which one?
Attorney Courier, thank you.
Do you want to reserve any of your time, Attorney Courier?
Yeah, I'll reserve 2 minutes, although I don't think I'm going to take that much time. First of all, good morning. My name is Doug Courier and I represent Stanford Management. And the two other respondents in this case, Melissa Cox and Joe Luce, who both work for Stanford Management. I do want to thank you for taking the time to consider this matter. I know a lot of work goes into it. Also on with me is Melissa Cox and Tom Rhodes representing Stanford Management. The complainant mentioned slashed tires, and that all took place after the charge was filed. I'd be happy to address it if the commissioners want to hear about it, but it doesn't seem appropriate. The things about the statement about her items being stolen and a sexual assault, that's all new to me. I have no idea what the complainant is referring to, so I'm not in a position to address that. That wasn't in the charge. I do want to just take a step back to say that Stanford does not want to be in a position having to give lease violation notices or to evict tenants or take steps to start an eviction process. All of the tenants in this location have disabilities. There are those with physical disabilities, those with mental disabilities, and those with both. I want to emphasize that this case goes beyond just trying to make sure that rent is collected. This is about trying to protect the property and, most importantly, about the well-being of the tenants. I was going to say that I didn't want to go into any detail about the lease violations, but rather would just answer any questions you have. But there's just a few things I have to correct the record. With respect to the things that she took, there's no indication that she took them and then started to do any cleanup. With respect to the security deposit, she definitely did receive notice of the amount due previously. This was not a surprise. With respect to the issue of the dog leash, I heard the complainant say that she had received multiple lease violation notices. I don't think that's true. I think the practice is, in fact, I know the practice is, the testimony is the practice is that they see a dog off the leash, they say you need to have the dog on the leash, and that if it keeps continuing, they will make it a formal lease violation notice. And in this situation, what you need to understand is that she had left the window open, and we vehemently disagree that that wasn't the cause of the pipes freezing. And then they were checking the film because the security camera, because there was some of the building materials there to repair the damage were missing. And on the camera, they saw her taking things. In particular, the one thing I do know for that she took was the bags that she mentioned, and she had with her dog who was not on a leash. And so it was, it just really emphasized that they needed to make it clear that this type of stuff just could not continue to happen. And really, what we're dealing with here is that both the frequency and the severity of the violations prompted the need to deliver this notice of lease violation. Beyond that, I think the investigator's report does a very good job of summarizing the facts and the laws of this matter. And we would ask that the commission adopt the findings of the investigator. The only other thing I want to mention is that after Stanford received the charge, it was not aware or under any understanding that she did not want direct communication on matters from people at Stanford. And so they did reach out to the complaint to say, we see what you shared in the charge. Can you please let us know who we should be in touch with? And we never received a response. And the complaint continued to have direct communications with those at Stanford, and more often than not initiated by her. And so with that, I will just pause to see if the if the commissioners have any questions for me.
Commissioner, questions for Attorney Courier? Being none, you'll have.
Yes,
Oh,
no,
Commissioner,
what are the most severe, rank the violations in terms of severity? You said it's the severity of the violations that causes you to evict this tenant.
As I look here at the lease violation notice, the damage to the property and leaving the window open and causing the water break obviously had financial consequences to the property that were significant. There was the effort to try to engage and get into the unit to try to deal with the issue, and the complainant really fought that and pushed back, and so didn't cooperate during this issue. And then with respect to the unpaid deposit, the issue there was that they had been trying to get her to address it, and she hadn't. With respect to the care and cleanliness of the property, that had happened multiple times, and they were trying to really make it clear it has to stop. With respect to the leash policy, that had happened multiple times, and they were trying to make sure that would stop. And so in some respects, it's hard, because if it's a one-time thing with a consequence, it's severe. If it's a smaller thing that happens multiple times and continues, then that raises the level of severity as well.
And that certainly is the case with the lease violation, that it's multiple violations that are not that serious in and of themselves, especially in the context that she says that it's fairly common.
And the stuff leaving the stuff in the hallway and leaving the leash, the dog off the leash, is things they had talked to her about previously and not issued a written lease violation, and it was happening multiple times. There are other tenants who have received lease violation notices for doing less. And in our position statement, we gave multiple examples of things that she had been leaving in the hallway, beyond just the one that she referenced.
Attorney Courier, I struggle with the fact that we're told that the complainant has mental impairments, at least one of which is considered a disability within the meaning of the MHRA, without regard to severity. So if this complainant potentially has a severe mental illness because of whatever that is, that's hidden from us, we're not talking about how that affects the person's behavior. I mean, this issue comes up, it's going to come up in the next two cases too. What is the severity of a severely impaired individual and how that affects their behavior? I mean, we just don't know. How do you react to that?
Well, I guess I'm a little bit confused. When I was referencing severity, I wasn't talking in terms of her mental.
No, I understand that. I've
Okay.
gone on to another use of severity. I'm looking at the footnote that says that she has a mental illness that by definition is I'm sorry, what is a disability a mental impairment, which is a disability without regard to severity. In other words, you don't have to, that mental illness is an impairment without regard to severity. So you could have a severely impaired person and that's affecting their behavior. That's affecting her social interaction, her ability to interact with the repairman, et cetera, et cetera. I don't know. I'm asking you to react to my puzzlement, but that's my
Yeah, I
problem,
mean,
I guess.
first of all, I understand exactly what you're saying because, you know, this is someone who, you know, we appreciate that this is the person's home. And we appreciate that with all the tenants who have disabilities, mental and physical, that, you know, we want to try to be supportive and allow them to thrive in their home. At the same time, it feels as though what's being asked here is to essentially modify our policies in a way that would is just not reasonable to, for example, allow behavior that would result in you know, substantial damage to the property and somehow excuse that, saying it's because of a severe condition, or alternatively to say that, you know, that other tenants, and this is in our position statement, talking about how fearful the other tenants are of you know, the complainant's conduct, and to modify our policies in a way that essentially allows this individual to impact the other tenants and their peace and quiet enjoyment of their homes doesn't seem like a reasonable solution. And you know, I think that ultimately, you know, there has to be some consistency of enforcing our policies and our rules, and that you know, there's just a limit as to how much you can be expected as a landlord to modify your policies for any particular individual because of the need to protect the property and the others who live there.
Yeah, thank you.
Ed, I just want to clarify the reference to it's a disability without regard to severity is from the statute. It's just one way of proving disability. There's that list of per se disabilities.
Yeah.
And that's where the standard comes from. It's not making a finding one way or the other about how severe a complainant's disability is. It's just if she has one of the listed conditions, she's automatically.
But is it, I hear you, Barbara, but is it relevant to know in this case how severe the disability is in terms of trying to make a judgment as to how it affects behavior?
I think we're looking at, we're not evaluating behavior so much as whether there was just, I mean, the question is whether or not if their decisions were discriminatory, not whether
Right.
the
Right. Yeah. I hear you.
Okay. I just wanted you to know where the phrase came from. That's really.
Yeah, no, I thank you. And as I say, we're going to spend the rest of the morning on this issue, in my judgment.
Any other questions for Attorney Currier? Okay, seeing none, you'll have about 5.5 minutes when we come back to you. Ms. Sanborn, you have 2 minutes if there's anything else you'd like to add.
I just wanted to add that every time I got a violation, I would see the other tenant's dog running around the yard and the building off its leash, even in the property manager's office at times, being pet and sitting in the property manager's lap. And there would be a cat running through the building and in the dining room. Cat just running through the building. And so I would let my dog off its leash and let it go about and do what it would want. So I would get a violation, but nobody else would get violations or anything, but I would. So, I mean, that would just be me and my disability, of course, because I'm stubborn. So that would be me. That's just how I am, you know, I would have to be, that's my disability. Because I always have to be that stubborn person, but that's just who I am. Because I have to have the last word, and that's just my disability, and I'm sorry for that, but that's just who I am, and I apologize. I'm sorry.
Any commissioner questions from Ms. Sanborn? Mr. Courier, you have about 5.5 minutes if you have anything else you'd like to add.
I'll just say, we don't know who this tenant is, and we don't believe that there's anyone whose pets are running around with, or dogs are running around without a leash. So we're just, it's hard to address that, but we definitely know that there have been other people who've had their dog off at a leash and that they've been spoken to as well. And it just hasn't happened with the same degree of frequency. Thank you.
Any commissioner questions for Attorney Courier? Okay, seeing none, we've heard from the parties. Next, we'll hear from Alex Brindley, the investigator assigned to this case.
Good morning, everyone, commissioners. My name is Alex Brindley. I was the investigator assigned to today's case. Few things off the bat. Barbara very kindly went over the disability without regard to severity, so I'm not going to touch on that. Essentially here, the crux is whether or not, lease violation was discriminatory, and based on my investigation, I did not find it to be. I'm open to any questions.
Commissioner questions for the investigator? We've heard from the parties and the investigator. At this time, we're looking for a motion. There are 3 proposed findings.
I move that we accept the investigator's recommendations as written. 1, there are no reasonable grounds to believe that Stanford management discriminated against Sanborn on the basis of disability. 2, there are no reasonable grounds to believe that Melissa Cox against Jolene Sanborn on the basis of disability. And 3, there are no reasonable grounds to believe that Lucy discriminated against Jolene Sanborn on the basis of disability. And finally, the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Do I have a second?
Second.
Any discussion?
Well, it's a shame she's not here to hear these comments, but I think she did a able job of representing herself. It's just tying the difficulties in her tenancy to her disability. There was just really no showing of that. So
Discrimination.
Been moved and seconded. The motion is to find no reasonable grounds on all 3 findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing.
Thank you for your time.
So the last 2 cases are the same petitioner and the same recommendation. Can we take them together in argument by giving, more time to both respondents or not?
I think, and Barbara, you can correct me if I'm wrong about this. So as opposed to the housing case that we just had where there were 2 complainants, but the facts were identical, in this case with these 2 respondents, I think the facts are dissimilar enough that we need to take them separately because the arguments are going to be a little bit different in each one.
Yep, I agree.
Okay. So we'll hear
Okay.
0067 first.
Yep. And the recommendation is for finding of no reasonable grounds, so we'll hear from complainant.
Attorney Mott, you have 10 minutes. Do you want to reserve any of your time?
2 minutes would be great.
Ready?
Good morning, commissioners. I am here today as representing a complainant who is here with me, Mr. Christopher McGonigal, and I'm a staff attorney at Disability Rights Maine. In short, this case is about a kind young man with a psychiatric disability who resided in disability housing at the respondent's premises starting in January of 2024 until he was involuntarily hospitalized on October 2nd of the same year after exhibiting disability-related behavior. A staff member subsequently obtained a temporary civil protection from harassment order with standard provisions due to his disability-related behavior, and respondent subsequently requested and after approval from their housing manager terminated his services on December 10th, 2024. The respondent's actions amounted to refusal to provide two disability-related accommodations, disparate impact, disparate treatment, and related theory of illegal eviction due to the severity of disability. In finding no reasonable grounds, the investigator misapplied law, overlooked facts, failed to analyze and distinguish those facts, and took the respondent's claims at face value. Today, I'm asking the commission to make its own determination to find that there are reasonable grounds to believe discrimination occurred on these theories. This case arises in the context of housing designed for people with disabilities, with the very goal to serve persons with mental illness who meet the certain eligibility criteria. In this case, my client has a known mental health diagnosis and submitted 2 accommodation requests, each by and through his attorney, to the respondent, a housing provider at the premises, along with 9 other residences. Briefly, the first request came on October 21st, 2024, where he sought a written clarification of the reasons he was being denied housing so he could determine whether to seek a formal accommodation. While respondent did engage in conversations with counsel, there were no alternatives proposed, no explanation beyond a third-party temporary court order, and after 46 days, when we received a written response, the written response did not provide the information requested and cited to a direct threat without a current individualized assessment. The second request came on December 12th, 2024. This request proposed a clinically informed meeting that mirrored HUD's direct threat analysis framework to collaboratively assess whether any reasonable modification could address safety concerns. On December 20th, respondent stated that their understanding is that that would not be a reasonable accommodation. And on January 2nd, they followed up stating that if the order is continued after February 10th, we would take the position that no accommodation is possible. Then, as the order was continued beyond February 10th, respondent reaffirmed that position on February 11th, stating our position remains that no action on the reasonable accommodation request is possible until the PFH is resolved. These amount to constructive and actual denial. In terms of disparate impact, respondents have a neutral policy. This policy is when a staff member obtains a temporary PFH against the resident will not be allowed to return to their home. This policy was only received by us in respondents' January 2nd, 2025 responses, as stated previously. This is a neutral policy as there's no individualized review, there's no balancing of rights, and this order is treated as a permanent bar that fails to consider the context in which such orders arise. Respondents' policy has a disproportionate and predictable adverse impact on people with psychiatric disabilities, as only people who meet Section 97 eligibility requirements, including the LOCUS, which is the level of care utilization system score, which can include a risk of harm dimension score of 4, are allowed to reside there. The dimension score of 4 means it's anticipated that individuals who reside in these residences may potentially exhibit behaviors such as suicidal or homicidal ideation and/or impulsive, aggressive, abusive behavior. This is what respondents are licensed and paid to support. So it's predictable that this policy of refusing a person to return to their home when a staff member has obtained a temporary PFH against that person, when that is due to the behaviors that the provider is licensed to provide support for, is something that could happen to every single person who lives in any one of these 145 residences under the same license across the state. The burden then shifts to respondent to justify the policy, that policy is necessary to achieve substantial, legitimate, and non-discriminatory interest, and that there is no less discriminatory alternative that would serve that interest equally well. Respondent demonstrates a legitimate interest of safety of staff, but they failed to make a showing that it was a necessary policy. Their defense that they believe relevant law would not require staff relocation as a reasonable accommodation is not a legitimate defense and instead a refusal to engage. They also failed to show the absence of a less discriminatory alternative, especially given the enhanced rates available pursuant to Director of OBH public testimony, and their defense of equivalent services is inadequate, So I'm aware of any legal precedent that with just a housing provider can defeat a disparate impact claim by pointing to another facility that the individual accepted under pressure of having no other option than homelessness. Additionally, in terms of disparate treatment and illegal eviction due to severity of disability, my client established his prima facie case, and the burden would then shift to respondent to articulate a legitimate non-discriminatory reason. Again, that reason is safety of staff as a legitimate reason. Then the burden shifts back to my client to demonstrate that this reason is pretextual or irrelevant and that the adverse action was in fact motivated by disability. My client established this by showing that it was a third-party court order that caused the decision, not other articulated reasons, such as the August 2024 transition planning, non-compliance with medication, or even respondents' assertion of aggressive behaviors. To prevail, my client most clearly demonstrated this by showing that the third-party court order is the reason for the decision. In respondent's reply, Exhibit 7, you will see that respondent agrees that the actions underlying the petition relate to his disability. Additionally, the behavioral health residential plan dated 5/28/24, effective to August 26/24, clearly indicates that they've reviewed with Chris that it is likely that he will be working to transition to other supportive apartment in the next 12 to 18 months, which doesn't sound like they were already planning for his discharge. Commissioners, this case presents discrimination under multiple legal theories as stated previously. The respondent's conduct has frustrated the very purpose of the FHA and MHRA. And this happened in housing designed specifically for people with psychiatric disabilities. Yet respondent believes these laws didn't apply to them and weren't something our residents had a right to. The commission has a vital role in upholding civil rights in housing and has historically recognized these rights for individuals with disabilities in Maine. We respectfully request that you uphold the integrity of the FHA and MHRA by finding reasonable grounds and reinforcing that individuals such as my client should not be denied access, process, or the rights to which he's entitled to as a person with a disability by finding reasonable grounds that discrimination occurred in this case on 4 separate but intersecting theories of liability. Thank you for your time and attention, and I'm happy to answer any questions.
Questions for, okay, yes, Commissioner Sanders and Commissioner Douglas and Commissioner Dick. Sure, good morning.
Morning.
So I'm having trouble with your argument, and I just want to make sure I understand it. So we've got a court order, right? A protection from harassment order that's been entered by a court, right? Maine Health is not a party to that action. Tell me, what do you expect Maine Health to do under those circumstances, right? So we've got a court order, it prohibits contact between your client and an employee. How would you have wanted Maine Health to deal with that particular issue? Did you want Maine Health to talk to your client about less restrictive alternatives than a full, denial of contact or denial of right to access space? Tell me more about that.
Sure. Thank you. So first, I think to clarify, these reasonable accommodation requests were seeking information about why he was terminated or why they were saying he couldn't come back, what services would be needed in order for him to return. And then that dialogue that mirrored the direct threat analysis. So it was not a reasonable accommodation with respect to the temporary order. Additionally, I understand that there are certainly competing interests here. But the question of what alternatives we were looking for was something we weren't even able to get to. Because respondent denied our accommodation requests, took 46 days to respond. And when we finally did get in writing that it was a direct threat defense that they were claiming, there was no individualized assessment that's required when a housing provider asserts a direct threat analysis. So that's what we were looking for.
Okay, thank you. Okay, Commissioner David?
Yes, I'm sorry, is it Attorney Mott? Is that? Yes, okay, yes, I saw that was your you're the one that filed the objection. My problem, I'm still focusing as I was in the last case on this business about without regard to severity. He has a mental health condition that's a disability by definition, without regard to severity. Could be very mild. How do you react to this? It seems to me that you beg the question by starting out your presentation by saying disability related behavior. How do you prove, is it in the record that somebody has said that this behavior of fantasizing about an employee being his wife and attacking her, closing the car doors, all of that kind of thing? Why is that disability related behavior? How do we know that?
I'd like to correct the record, as I'm not aware that there's anything in there about him attacking. I don't believe that that's
About his
supported
what?
by the record. I don't believe that him attacking is supported by the record, so I'd just like to offer that clarification.
I thought it was closing the car doors or trying to get in the car, which I consider an attack. And I
Sure,
believe
and
that's in the
I
record.
won't litigate that definition. That's just not the word I was using in there. And in terms of severity of disability, I think, so that is the qualification of what we look to if somebody has a disability under law. When specific to these housing providers, as I mentioned, you can only live there if you meet a certain eligibility requirement in Medicaid or Maine care rules, which include that locus score, the level of care utilization system score, which anticipates that people living in these facilities, residences, have up to a level 4, which includes things like suicidal or homicidal statements or aggressive assaultive behavior. So that's how I would answer that. Any other?
Excuse me, Kit, does it prove too much, Attorney Mott? Does it say that any untoward behavior is necessarily disability related behavior and therefore we ought to consider that?
So I would instead point
seems like he gets a free pass.
Certainly not. We were requesting the reasonable accommodation process that should be guaranteed to individuals under fair housing. And that is what we are focusing on in this case. There are the elements certainly of disparate impact and disparate treatment, but reasonable accommodation, I believe, is the clearest here. If you look to Respondents Exhibit 7, this is a joint motion to continue in the temporary protection from harassment order. And the third point, the 6th point says the parties agree, the parties being Mr. McGonigal and his attorney for that issue and respondent, is that the parties agree that the actions underlying this petition relate to Mr. McGonigal's behavioral health condition.
Okay. Last question. What is the importance or lack of importance of medication compliance, his compliance with medication recommendations?
Medications
in the record. If it's in the record.
Yeah, I think it is.
Then it has to be into the report.
Yeah, so medication compliance, is again, I think, an expected part of respondent services, as individuals might not take some of their medications, and likely would not have a court order that would force them to. So I would not weigh it as heavily as the respondent does, in terms of, there's very clear in that statement that it's related to his disability, and then further in respondent's replies, it was all citing to that temporary order. So that's what I would focus on.
Yeah, one more question. Is he in another institution now, separated from this employee being in another residence?
So not in an institution. He is living at another residence now, yes. And I am aware that respondent suggests that that's equivalent services. But like I said, I'm not aware of where equivalent services being accessed through housing would absolve respondent from requirements under the Fair Housing and Maine Human Rights Act.
Thank you.
Is the other facility a Maine House, Maine Health operated facility?
The other residence is operated by a different agency.
So essentially, so the challenge that you're articulating is not necessarily that Maine Health made a mistake by barring him from the premises, but you wanted Maine Health to engage in a discussion with you, right when the PFH was issued about what kind of restrictions could be appropriate. Could he, return to have access to the facility? It's really, right, it's the matter that Maine Health said, we're not gonna engage in that discussion until further notice. So really, it's a question of timing from your perspective. Is that correct?
Really a question of that we requested a reasonable accommodation, and the response we got was that they wouldn't engage due to this order.
Sure.
So I think that for the timing is related there certainly, but it's not based on the order, it's based on his housing rights.
That's the distinction. I'm just having trouble with it.
No, and I understand, yeah.
That's the distinction. He's barred from the premises, right? So by court order. My sense, right, is that if you and your client wish to challenge it, right, your remedy is back in the district court, right, in the PFH matter. It's not with a sort of further ongoing discussion with Maine Health at that time, Maine Health at that time. So that's the sort of trouble that I'm having with your arguments.
And so I think if that were the rule to come out of today, my understanding is that if there were ever a staff member to choose to go this route in one of these residences across the state, the housing provider would be absolved of their requirements to follow the Federal Fair Housing Act and Maine Human Rights Act, because that PFH, that court order, is a third-party court order, and that would be creating an absolute bar on his return and making it so there was no need to go through the direct threat analysis.
Any further commissioner questions for Attorney Mott? And you'll have 2 minutes. I'm gonna pause us here just for a second to discuss. So we have the rest of this case, one more case after that, and then what I anticipate will be a fairly brief executive session.
Okay.
If you would like to order lunch, we should probably put that in now. Okay. If you think you can hang in there and wait until after the meeting, totally up to you. I have Whipper's menu right here. You can highlight what you want and give it back to me. I think it will get here before we are done with the second case. Okay, great. Yeah, highlight what you want and put your initials next to it. Thank you, Colin. Ordering pizza.
I want lunch delivered up here.
Okay, great. We'll send it up there. You should get it in 5 or 6 days, and I'm sure it'll be fine by then.
I will bring it personal. You're gonna have to house me.
Yeah.
That's right.
I'm gonna let Attorney Rideout begin her presentation while I trust that we can all multitask. So Attorney Rideout, you have 10 minutes. Find my timer. Do you want to reserve any of your time?
My aspiration is to reserve around 90 seconds, but we'll see how I do.
Okay, good. I'll just start you at 10 and you'll have what you at the end. Okay.
Perfect. Thank you. Hello again. Laura Rideout for Respondent Maine Health Behavioral Health. This case is about lawful termination of complainant's level 3 private non-medical institution, or PNMI, residential mental health treatment services at a facility operated by Maine Health Behavioral Health in Biddeford called Crescent Place. The PNMI regulations and the Maine Human Rights Act contemplate that a disabled person can both meet eligibility requirements to receive services, and also that it would not be discriminatory to terminate services if the person poses a direct threat. The investigator's report reflects a careful synthesis of a large record and complainant's written objection and the comments made today do not point to any errors or omissions that undermine the investigator's ultimate findings or conclusions. Maine Health Behavioral Health respectfully urges the commission to enter a no reasonable grounds finding consistent with the investigator's recommendation. What I plan to do now is walk through the three theories of liability that have been alleged and provide Maine Health Behavioral Health perspective on each of them. So the first one was disparate impact liability. The charge alleged that Maine Health Behavioral Health has a policy of allowing its staff to file protection from harassment orders against residents who engage in disability-related conduct. The investigator appropriately concluded that Maine Health Behavioral Health has no such policy, and in this case was simply reacting to the fact that a staff member had chosen to petition the court for protection. The investigator also concluded that even if Maine Health Behavioral Health's actions did constitute a policy, there was no discriminatory disparate impact because it was designed to prevent harm caused by residents who are posing a direct threat to others and not to categorically exclude disabled individuals from services. This is the correct result. Complainant's concern appears to be that disabled people who exhibit behavioral issues will have difficulty accessing services or housing. But the PNMI regulations and disability law both acknowledge that there is a limit that is reached when an individual exhibits behavior that constitutes a direct threat. Complainant is represented by counsel in the protection from harassment matter. He could have moved to dissolve the protection from harassment, or he could have contested it at hearing, but he has instead voluntarily agreed to continue the proceedings, which means that those protections remain in place in the interim. The second is failure to accommodate. Complainant alleges that he made two separate reasonable accommodation requests and that Maine Health Behavioral Health discriminated against him when it denied or constructively denied those requests. As Attorney Mott mentioned, the first was made in October of 2024, and it asked Maine Health Behavioral Health for information about whether it was able to meet complainant's clinical and non-clinical needs. And the second request was made in December of 2024 and asked Maine Health Behavioral Health to rescind its decision to deny his return to Crescent Place and to meet with him to identify reasonable accommodations that could eliminate the safety concerns. The investigator questioned whether these requests for information even constitute a request for reasonable accommodation. Nevertheless, still evaluated the substance of the claim and ultimately rejected it on the grounds that Maine Health Behavioral Health did provide the requested information, and allowing complainant to return to Crescent Place was not a reasonable request while the protection from harassment remained in place. Complainant faults Maine Health Behavioral Health for taking too long to respond to these requests, repeatedly referencing that the first written response was provided after 46 days, and that Maine Health Behavioral Health has stonewalled the complainant and left him in limbo. And in support of these claims, complainant references two cases where failure to timely respond was deemed a denial of the request. Both of those cases involve completely different situations than what transpired in this case. One of those cases involved an accommodation request that remained pending for over a year and was not implemented even after it had been approved. And the other case cited by complainant involved a reasonable accommodation request that was pending for 127 days with no action taken, and defendant was unable to provide a timetable, state the status of its review, identify when the review be complete, or state who the ultimate decision maker was. This case doesn't involve delay or inaction. It does involve an impasse that was reached between the parties. The only proposed accommodation that I understand as a possibility here and that I've heard articulated by complainant is that Maine Health Behavioral Health should have reassigned the staff member who petitioned for the protection from harassment. But Maine Health Behavioral Health does not believe that the Maine Human Rights Act requires adverse employment action to be taken against a staff member in order to accommodate a program participant who threatened her safety. Maine Health Behavioral Health's position, consistent with the investigator's findings, is that it reasonably responded to the informational request and it has not denied a request for a reasonable accommodation. Also relevant here is the fact that the state approved complainant's placement at another PNMI facility, and he transitioned there after he was discharged from the hospital. So he was never without comparable housing and residential treatment services. The final theory is disparate treatment. The charge alleges that Maine Health Behavioral Health discriminated against complainant when it refused to allow him to return to Crescent Place on account of the nature and severity of his disability. The investigator concluded that Crescent Place exists to provide residential treatment services to individuals with behavioral health disabilities. Maine Health Behavioral Health did not discriminate against complainant because Crescent Place continued to provide services to him even when he became non-compliant with his treatment plan, with the resulting escalation in behavioral concerns. It only sought to terminate his services after he posed a direct threat to its staff member, and a protection from harassment had been ordered, barring him from being in the vicinity of her place of employment. Complainant seems to caution that protection from harassment could be used to categorically deny access to facilities or housing by people with disabilities. But there are, of course, several safeguards that would protect against this type of outcome. First, protections from harassment can be challenged, and they will not remain in place if a judge determines that they are not factually warranted. Further, if behavior does not amount to a direct threat that cannot be mitigated by reasonable accommodation, then the disabled person will be entitled to continue receiving services or housing. And finally, individuals receiving services at PNMIs like Crescent Place are protected insofar as there is an expedited administrative appeal process that can be used to challenge termination of services. I want to conclude by bringing it back to the underlying facts. Maine Health Behavioral Health requested approval to terminate services after complainant made a verbal threat involving homicidal and suicidal ideation and left the facility in search of the target staff member. Law enforcement brought him to the ED following this incident, and he was hospitalized and received inpatient treatment for approximately 2 months. His services were appropriately terminated under the PNMI regulations, and the state facilitated his placement at another PNMI facility following his hospital discharge. At the time of the discharge, the targeted staff member was still employed at Crescent Place, and the protection from harassment was still in effect. Maine Health Behavioral Health did not discriminate against complainant and has attempted to work cooperatively with his attorney, notwithstanding a difference of opinion about what the law requires in these circumstances. I thank you for the opportunity to present. We respectfully request that the commission adopt the investigator's no reasonable grounds finding, and I look forward to answering your questions.
Commissioner David.
I just want to confirm, Attorney Rideout, that you said he had counsel in the protection from harassment case. Is that correct?
That's correct. It was a different attorney than Attorney Mott is not representing him in those proceedings. A different attorney is.
Okay.
Commissioner
That's all.
Sanders.
Just curious, Attorney Rideout, I heard the respondent say that one of the suggestions for modification could have been, right, was reassigning the staff member who was the subject or the plaintiff in the underlying PFH matter. Did the complainant make any other suggestions about what could be an adequate remedy here in any regard?
No, Commissioner Sanders. As Emily Mott explained during her presentation, the nature of the requests that were made for reasonable accommodations were really informational in nature, and there was never any specific requests about modifications at Crescent Place's facilities in order to potentially accommodate him. And we did try to endeavor to evaluate whether there were any reasonable accommodations that we could make. And our position is that protection from harassment really created a threshold barrier that made it challenging to do that. Obviously, there's also procedural rules that have to be followed. Maine Health Behavioral Health does not have authority under the PNMI regulations as a licensee to accept or terminate services. All of that has to get funneled through the agency.
Thank you.
Any other commissioner questions for Attorney Rideout? Great, seeing none, you will have 1 minute and 49 seconds when we come back to you. Attorney Mott, you have 2 minutes.
Thank you. I will try to get through as much of this as possible. First, I want to note, respondent noted that the investigator pointed to our informational request as potentially not being a reasonable accommodation request. The Maine Human Rights Commission precedent under Shaw v. Genesis, it mirrors that reasonable accommodation request for information. And in that case, that was deemed to be a reasonable accommodation request. So that is actually the commission's own precedent that the investigator suggests is not. I do have other issues with the investigator's report that are laid out in my objections, but wanted to focus on the law in my response. Additionally, the PMMI regulations are not at issue here. And I believe that the respondent was citing to the case Nichols that they provided, which was an administrative appeal, where it was previously a Maine Human Rights Commission case where those were not found to be important. The investigator failed to analyze cases such as Broome to determine whether there was a reasonable accommodation. And we didn't reach an impasse. We weren't able to even get to the direct threat analysis, so we couldn't make suggestions. And this would eliminate safeguards in housing law. That's what we're here under, not the protection from harassment order. Additionally, I would just point to the case we provided and was not distinguished from in the report with Bridgewaters, which was an individual who had gone off his medication, had a serious mental illness, physically assaulted his physically disabled brother, pled guilty to 3 related charges. And in that case, it was found that the housing provider still had obligations to go through the direct threat analysis. Thank you.
Commissioner, questions for Attorney Mott? Attorney Rideout, you have 1 minute and 49 seconds if there's anything else you'd like to add.
I think briefly, I'll just say that in response to that last point, there's a suggestion that there was no direct threat analysis that took place. We dispute that suggestion. The record contains evidence that the factual basis for that is what filtered into the request of the state agency to terminate services. The factual basis is the same as what's reiterated in the protection from harassment order, and all of that was communicated with complainant's attorney as those communications were taking place in late 2024. Thank you.
Commissioner, questions for Attorney Rideout? Seeing none. Thank you both. Next, we'll hear from Nooper Leva, the investigator assigned to this case.
Good morning, investigators. Good morning, Commissioner. I apologize. It's been a lot of me today. I don't have anything to add that's not in my case. Both parties have presented their cases as they did to me, and my findings still stand as they are. So if you have any questions for me, I'm happy to answer them.
No questions for the investigator. Okay, thank you, Nooper. We've heard from the parties and the investigator. This time we are looking for a motion. There is one proposed finding.
I'd like to move that we find that there's no reasonable grounds to believe that respondent discriminated against complainant on the basis of disability, and the complaint should be dismissed.
Been moved and seconded. Discussion.
Yeah, he's not discriminated against because of his disability related behavior. He's treated exactly the way his disability related behavior requires. He's a threat to an employee.
Yeah, I agree with that. I would just add that, I think Attorney Mott here has made a Herculean effort to get around, to advance what I consider to be a profoundly difficult case.
Right.
Ultimately, I think it comes down to the threat, which is not in dispute in this case, as far as I understand it. The court order, I just don't know how you get around the court order and what it prohibits. I understand all of your arguments, and I think you've really gone above and beyond in presenting these arguments here, but I don't see how you get around that.
Any further discussion? Being none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing. And can we just take a couple of minutes? I want to check in with Colin and make sure that that order got placed before we move on to the next case.
Sure. We all set?
Hey, just like that. Oh, great, now he's leaving.
Okay, we'll call the last case. To me, it's a companion case, but it's Christopher McGonigal versus Maine Department of Human Services, H250069. Again, the recommendation is for finding of no reasonable grounds. We will hear from complainant's counsel.
Have 10 minutes, Attorney Mott. Would you like to save you that time?
2 minutes.
When you're ready.
Good morning, almost afternoon. My name's Emily Mott. I represent the complainant, Mr. Christopher McGonigal. Again, this case does arise out of similar facts, but this case is in respect to different reasonable accommodation requests and to respondent as the housing manager. Again, this happened where he was living in disability housing managed by the provider, and they are housing provider managed by the respondent from January of 2024 until he was involuntarily hospitalized in October. There was a temporary PFH filed. He was subsequently terminated from his housing. The respondent's approval of the provider's request to terminate my client's housing due to his disability without any detailed inquiry, and the subsequent outright denial of his reasonable accommodation request. The respondent's actions also in our argument amount to disparate treatment and illegal eviction due to the severity of disability. Again, while the investigator concluded that there was no reasonable grounds, the investigator misapplied law, overlooked critical facts, and failed to analyze or distinguish those facts based on applicable law, took the respondent's claims at face value. Today, I'm asking the commission to make its own determination to find there are reasonable grounds. This case arises in the context of respondent being housing manager for housing designated for people with disabilities, such as my client. For a housing manager to deny a reasonable accommodation while explicitly denying that housing law is applicable to them fails to engage in the required process and amounts to unlawful discrimination that contradicts the purpose of the housing itself. Briefly, as my client was in the midst of his reasonable accommodation request with provider, my client, through counsel, made a request on November 15th of 2024, asking respondents to rescind its authorization of provider's request to terminate my client's housing, and to refrain from considering further requests to terminate his housing and services while the reasonable accommodation request from provider was ongoing. In response, respondent then issued its decision on December 6th, denying my client's reasonable accommodation request, stating that the MHRA and FHA cited in the request do not apply to this matter. Then cited to the direct threat defense without proposing any alternatives and without completing the individualized direct threat analysis as required. It was just conclusions, and then 4 days later, provider terminated my client's housing. Again, with disparate treatment, my client established his prima facie case, and then the burden shifts to respondent to articulate their legitimate non-discriminatory reason. The report states that this reason was that my client posed a direct threat to an individual employed by provider. While safety of staff is a legitimate interest, respondent again didn't engage in the reasonable accommodation analysis. Their defense that they believe that relevant law would not require staff relocation as a reasonable accommodation is not a legitimate defense. The burden then shifts to my client to demonstrate that that reason is pretextual or irrelevant and that the adverse was in fact motivated by disability. My client established this by demonstrating how respondent clearly cited to direct threat and only provided conclusions with no analysis. That their defense that he was not put out on the streets or institutionalized is inadequate and just a refusal to engage. They used my client presented evidence of their inflammatory language that respondent used in their replies and casted doubt on the stated reasons for denial. Again, their articulated reason of direct threat is not accompanied by the individualized risk assessment and only provides conclusory statements. My client then demonstrated that he would not have suffered this adverse action but for membership in the protected class although that status need not be the only reason for the decision. He demonstrated this by showing that respondent's approval for provider to terminate his housing came when he was involuntarily hospitalized due to his disability, based on direct threat due to behaviors associated with his disability, with no direct threat analysis. Despite respondent having not engaged in any analysis to determine what my client's treatment status was, whether he posed a current level of risk, or whether there was a potential for a reasonable accommodation, the investigator's report refers fully to the request made by provider and concluding that my client failed to carry his burden. In short, the denials were based on fear, not fact, and the law doesn't allow housing providers to substitute speculation for the civil rights of people with disabilities. This case presents discrimination under theories of reasonable accommodation denial, disparate treatment, and illegal eviction based on severity of disability. Respondents' conduct has failed to recognize their role in housing, specifically related to managing housing for people with disabilities. We respectfully request that you find reasonable grounds that respondent housing managers' conduct violated state and federal fair housing laws through the denial of reasonable accommodation and disparate treatment based on disability. Doing so will reaffirm, instead of tear away, the housing rights of disabled individuals in Maine, as if no reasonable grounds were accepted, it would effectively create a new categorical rule which would allow a bright line exemption based solely on a third party's court action without an individualized evidence-based analysis, even in circumstances such as this, where the tenant alleges the underlying behavior was linked to a disability and has since been addressed, thereby shielding the housing provider in totality. Thank you for your time, and I'm happy to answer any questions.
Sure, Douglas.
All right. First of all, these comments about a bright line, I think you're a little bit too far with that, I think. I understand where you're going with it, but I think it's a little bit too far. The fear, or the actual question, you said, findings based on fear, not fact. And I don't understand what you mean by that. I mean, what we're talking about here is somebody that made a threat, right? There was a PFH, there's an order, right? Some issues in resolution conference. Your guy says he doesn't want to dispute these allegations. And that he didn't think it was reasonable for him to return to the premises to the board and was finalizing asbestos. This is in the report at page 3. I don't understand what you're getting at when you say fear not fact. What we
Sure. So 2 things. The first is that, as seen in the record, this is a temporary protection from harassment order with standard terms. Filing an order, so the final hearing has not happened yet. The final hearing is when these facts will be litigated and when it will be determined whether there is an ongoing threat and the PFH needs to continue. That has not happened at all throughout this case. It has been a temporary order the entire time.
But the problem is that your guy doesn't, as I understand it, he doesn't dispute, right? He doesn't dispute that he made this threat. He doesn't dispute that he then went looking for the staff member, right?
So I know, I think you're referring to the IRC, right?
Yeah.
So in the IRC, it was prior to our being able to file our responses, and was held with both cases together. So there were many people there, many people in suits. And the investigator there was the narrative that my client's attorney, myself, had requested something other than what I requested. The suggestion was that I had requested his return to housing when that was not what I had requested. So with that narrative that my client was hearing, along with the fact that the request was not for that, it's entirely reasonable for him to agree that he shouldn't be able to return, as I would assume any person here would not voluntarily choose to violate a court order. I also say that response places improper weight on his answers in the IRC, because these answers came without a proper opportunity to be able to fully defer to me or consult to me as his retained attorney.
I don't want to get into it back and forth with you, but let me just ask it this way. So as you stand here right now, are you disputing these allegations? Are you disputing Let's be specific. Are you disputing that he made this threat?
So I recognize your question. And I'm not here to litigate the PFH. And so in this, we described the allegations, and no, we did not dispute the allegations. Because disputing those allegations is not relevant. You know, if we had gotten to the direct threat analysis, and respondents said that the individualized assessment was based on these facts, then we could have provided in response evidence of rehabilitation, evidence of change since then that would mitigate that risk. That's what we didn't get to, and that's what I'd like to focus on, because that's the core of the housing argument reasonable accommodation issue here.
Good. I'm gonna let this go for now. It's gonna come back.
Sure.
Commissioner Sanders. Yeah, just in follow-up to Commissioner Douglas's question. Yes to all that, and isn't the appropriate time to have, because that's the issue, right? When do you start having those conversations? Do you do it, right, your point, as an accommodation while the PFH is pending, or right, is it appropriate and reasonable to wait until that underlying set of circumstances has resolved, and then you have a discussion about, is it appropriate for, you know, in this case, your client to return? So why, to put a fine point on it, why is it inappropriate for, in this case, right, the respondent here to have wanted, you know, to sort of to wait until the underlying PFH had been resolved, right, relying on Maine Health's assertion of the direct threat? Why is that an
So it was not a request.
Let me, isn't it a moot point, right? While that PFH is pending, isn't the accommodation discussion a moot point?
It wasn't a request to return first, it was the request for information. And I'm not aware of any housing precedent that would suggest that something like this allows a 9-month-long delay in the reasonable accommodation process, which would have, if we had accepted that when stated in January and restated in February from the other case, it would have moved out until not even happened yet for us to be able to address that. And I'm not aware of anything that would support a delay in a reasonable accommodation request being that long. Additionally, this request and response came in December 6th, same day as a response from the provider. So it's our position that that would not stop the process and would instead cause a delay, which under fair housing law, under the HUD and DOJ joint statement would be an undue delay in the reasonable accommodation process.
Commissioner questions for Attorney Moth? Okay, seeing none, we'll have 2 minutes and we come back to you. Attorney Carter, you have 10 minutes. Do you want to reserve any of your time?
I'll reserve whatever I have left.
Okay, whenever you're ready, go ahead.
Good morning, Commissioners. My name is Jeremy Carter, Assistant Attorney General, appearing on behalf of the Department of Health and Human Services, Office of Behavioral Health, respondent in this claim. We encourage you to adopt Commissioner Leva's finding in this case, her recommendation of no reasonable grounds to believe that OBH discriminated against Mr. McGonigal. I think the facts and background of this case have been pretty well hashed out by both parties in a couple of cases here. I'll just point out a few things that are important to your consideration of OBH's position specifically. We were asked, OBH was asked to authorize the termination of services of Mr. McGonigal after he had made a threat to one of the provider's employees. Maine Care rules, which govern the reimbursement of how OBH pays and reimburses providers who operate PNMIs, states very clearly that services can be terminated, granted permission is requested from the provider, and it can be done if there is a threat of imminent harm. Given what was provided to OBH, given that it didn't appear that Mr. McGonigal contested that he did what he was alleged to have done, OBH agreed and said, we will grant the termination of services request. The request that we then got from Mr. McGonigal's counsel, and I say request as opposed to reasonable accommodation request, because we don't believe it was a reasonable accommodation request. What it essentially asked was for OBH to reverse its decision and not make any other decision until Mr. McGonigal and his counsel had time to sort of search for information from the provider. So OBH was asked, reverse your decision and wait. Now, Attorney Mott has suggested that this doesn't mean that we were allowing him to return to the Biddeford facility, but that's precisely what it would have meant. Had we reversed the termination of services, he would still be entitled to services as he had received them. Now, yes, he was under psychiatric care, but had OBH reversed that termination of services as Attorney Mott requested, Mr. McGonigal would have been fully and legally entitled to return to the Biddeford PNMI, which just wouldn't have been safe. And so ultimately, the ADA coordinator for the Department of Health and Human Services denied that request on the grounds that it wasn't particularly a disability-related request. It was more sort of an administrative, it's sort of akin to asking for a stay in court, say, or almost an injunction. Hey, please don't do anything until we sort of sort some other matters out. That was what it essentially was. And that even if it was an appropriate accommodation request, the imminent threat situation, again, which there is no denial or sort of countering from complainant that he did threaten this employee, given those two things, the accommodation request, to the extent it was one, was denied. Just a few other points that separate. I'll state for the record, it's not important to the resolution of this. Investigator Leyva did a good job with her report without sort of diving into this thorny legal issue. But OBH does not accept and does contest the idea that we are a housing agent in this case, that we represent housing. We are a Maine care provider that reimburses some residential care treatment. We're not housing agents for nursing homes, psychiatric hospitals, long-term stay facilities, residential hospitals, anything like that. And we're not the housing manager of a PNMI. But as I said, Investigator Leyva was able to resolve this correctly, in our opinion, without going into that. But I do want to state it for the record. I think the issue that really sort of separates this case from perhaps the other one is that even if we accept that OBH was entitled to accommodate this request, or that OBH was required to treat the request as a reasonable accommodation, try to find him other housing, whatever it might be, OBH did in fact do that. As has been alluded to and as has been stated, Mr. McGonigal is now in a different PNMI run by a different provider in Portland. OBH facilitated that. OBH, he's a Maine care member. We still look after him the same way we did when he was at the Biddeford location with a different provider. There was some reference in the Issues and Resolutions Conference that Mr. McGonigal is less satisfied with this PNMI than he was in the Biddeford one. That's understandable, but really PNMIs are a scarce resource. There are far more people who need them than there are beds available. OBH does its best to try to give people a PNMI that best suits their needs, their interests, their abilities to pay rent. But in this case, the Portland option was the best that was available. He was immediately allowed to transfer to that location upon his release from the hospital. And it didn't involve him having to come back into contact with the employee of the provider in Biddeford, against whom he had exhibited some erratic and potentially dangerous behavior. I think another area that's been addressed in this hearing, I believe by Commissioner Sanders and perhaps by Commissioner David at different points, what would Mr. McGonigal have had us do? What would the accommodation have been? What would the modification have looked like? Attorney Mott has suggested that neither we as OBH nor the provider ever engaged in that conversation. I think the reason that is so is because when asked, Ms. Mott couldn't really give an answer to that. The answer as to how we would accommodate this would be by removing that employee. That would be how you would accommodate this situation, is removing that employee, either transferring, hopefully not terminating, but that would be, I think, arguably an adverse employment action in response to her filing of a PFH, which is in itself a violation of the Maine Human Rights Act. That would be taking an adverse action for the filing of a PFH or PFA, which is protected activity. So I think that is another area where this Mr. McGonagall's case respectfully just falls down. Both OBH and the provider have been accused of not meaningfully engaging in assessing what accommodations could have been provided. Well, it doesn't sound as if Mr. McGonagall even really knows what other accommodations could have been provided, other than the one that I think we can all agree is facially unreasonable, which is to affect the employment conditions of this innocent third-party victim. OBH was not willing to endorse that. OBH thought it could and was able to find him new PNMI services. He was there at least as of the date of the Issues and Resolutions Conference. I believe he is still there today. OBH certainly did not and would not abandon Mr. McGonagall. There were just clearly problems with him remaining at this facility, and it took those problems seriously. With that, we'll respectfully request that the Commission adopt Investigator Leva's recommendation of no reasonable grounds, and I'm happy to take any questions.
Commissioner, questions for Attorney Carter? Okay.
Thank you.
You'll have about 2.5 minutes when we come back to you. Attorney Mott, you have 3 minutes and 57 seconds.
Thank you. First, I'd like to address respondents focused on their claim that they are not a housing provider. And I would dispute their ability to make that objection, as they didn't file an objection with the commission indicating that they disagreed with that finding. And my understanding is that is the only way you are able to disagree with findings is if you can file an objection. And that was not something that they did. Second, they discussed how they were asked to authorize termination of his housing and services by the provider. My understanding is that OBH, as the overseer and manager of these housing residences, would have wanted to know whether there was a direct threat and would have wanted to engage in the individualized analysis, especially given that director of OBH testimony suggested that there are enhanced rates available for people returning from hospitals to these PNMIs. Respondent also suggests that this was not a reasonable accommodation request. Again, this was a request for information that is mirrored directly from the Shaw v. Genesis case, in which the commission found that that was in fact a reasonable accommodation. And the investigative report again suggested that the Human Rights Commission precedent was not actually its precedent. Whether he's less satisfied or not is not a question here. The question is whether he had a right to the housing rights that he should have a right to. If there had been a direct threat analysis, again, you could have gone through the whole process and gone through whether there were accommodations that were possible. The respondent suggests that we didn't provide any. It wasn't on us to provide any at that point. It was on them to complete the individualized direct threat analysis. As to employment law and protections versus housing law and protections, I'm not aware of any precedent that would suggest, as respondent did, that employees' employment rights are far stronger than disabled individuals' housing rights, which is what respondent suggests here. And I'm just making sure I got everything. Again, the housing that he's in now, whether it's equivalent services, we would disagree on that, because the rent is more expensive. It's in an area he's unfamiliar with a different clinical team. There's a lot of differences. And additionally, I'm not aware of precedent that would suggest an alternative housing arrangement as something that would absolve a housing provider or housing manager of their responsibilities under fair housing law. Thank you.
Commissioner, questions for Attorney Mott? Very much. Attorney Carter, you have 2.5 minutes left. If there's anything else you'd like to add.
Thank you. Just very briefly, Attorney Mott suggested again that OBH should have wanted to know if there was a direct threat, should have conducted a direct threat analysis. I believe, as Commissioner Douglas pointed out, that argument is fairly ineffective when no one, including Mr. McGonigal, contests he made a direct threat. That threat was made. OBH knew it at the time. It was part of the documents that were submitted to them. And at no point through the sort of back and forth that was had with Ms. Mott and OBH was that ever disputed. Ms. Mott also said that the accommodation request that was made was a request for information, which the commission has previously recognized as being valid. That perhaps describes the request that was made to the provider. That was not the request that was made to OBH. OBH's request was not one for information. It was for a reversal of its decision and to essentially not act again unless and until MBH, or excuse me, the provider did something different. Again, we just asked, we think Investigator Leyva went through this very well and effectively, and we respectfully ask the commission to adopt that finding, that recommendation. Thank you.
Commissioner, questions for Attorney Carter? Seeing none, we've heard from parties. At this point, we'll hear from Nupur Leva, the investigator assigned to this case. You're almost done.
Thanks, Kit. Good afternoon, commissioners. Once again, the parties have laid out their cases as they were laid out to me, and nothing that I have heard in the presentations along with the submissions of disagreement changes my recommendation, but I'm happy to answer any questions if you have them.
Just a comment. You've been very succinct today.
Thank you.
Any questions for Nupur? All right, seeing none, we've heard from the parties and the investigator. At this point, we'd be looking for a motion. There is one proposed finding.
I move that we adopt the investigator's recommendation as written, that there are no reasonable grounds to believe that the Department of Health and Human Services of Pacific Behavioral Health discriminated against Christopher McGonigal on the basis of disability, and that the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second. Been moved and seconded. Any discussion?
Yeah, I'll just say, as I said in the last case, I appreciate an attorney that's willing to take on a difficult case and come here and argue passionately. Mr. McGonigal, I want you to know, and I'm a litigator, I want to say this directly, we've had excellent representation here today.
I certainly think so too.
I think so, but on a profoundly difficult case. And again, I think where the rubber meets the road in this case is that we had serious threat, unfortunately, not really refuted, not really disputed. Treatment, there's still troubling references. And we have a court order, so.
Yeah, I wish I could have addressed that sooner in court, but we've had to do some continuances, but thank you for your time, your patience. I appreciate it.
Well, thank you, sir.
Any further discussion? All right, seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Unanimous.
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and council is confirming the results of the hearing.
That completes the hearing list. Pursuant to 1 MRSA section 4056E, I move that the commission go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
always a friend. Every
All right.
time.
Moved and seconded.
I thought,
Any discussion?
I thought it might fail.
All right, seeing none, if you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sisson.
Yes.
Okay,
That one,
that is lunch.
No lunch for you.
Will you mute us, please, and turn the camera on?
No soup for you.
Just find Commissioner Sanders' luncheon, shall we? Everybody, hurricanes.
All right, Ed, I'm just gonna try to sort this out while we.
Sure. Just waiting for an invitation.
Yeah.
Sorry, that's not like the way I can't. I have to tea. Hi, guys. Yeah, I'm out of here. We're taking bus.
Yep. Oh, good morning, sitting over there. His dad.
DRM intern, disability right.
Man.
You need that one.
Yes. Shit.
Sure is. Yeah, I'm in my firewall. It's
Turn your hotspot while you're driving.
no, I'm like always set on to off wheel or. Oh, yeah, so I do, but it's.
Okay, we are out of executive session. I need a motion not to litigate E 23-0070 Zingu versus Abbott Labs and PA 230170 Caldera v. Waterfront Concerts at all.
So moved.
Right, any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David? You're muted.
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
And I need a motion to accept the agreement in H 30374 B, C, and D, MHRC versus Tedford Housing et al.
So moved.
Second.
Discussion? Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.